now you have to worry about is, what did they breach? And then once they did a bad faith move, violated a statute and code, say, then you could move for breach of trust.
So that would be like a class action movement of beneficiaries then?
Well, not really. Well, all they could be, like Quaitam or something like that, it could, but you could bring an individual case up against it. Mm-hmm. Beneficiary can do that.
And then I would move against them to correct the breach, or I'd move for damages or combination.
Uh-huh. Right.
Okay. I was going about it the wrong way.
Yeah, I wouldn't have to prove that I was grantor because the trust has already been in existence. Public trust is easy to prove up, and you've got to be the beneficiary if you're part of the public.
Right. Especially public education.
Yeah.
And so I could allege that we have they dumbed down the educational system or whatever, and have caused irreparable damage to the beneficiaries.
Right. You just have to create some records to certify that there was a breach or damage done in bad faith, which would be public trust.
Well, a failing school would be sufficient, wouldn't it? Low test scores?
Yeah. True, right. Yeah. Anything else?
No, I was just thinking if I had copies of the low test scores, would that be res? But I'm not going to go there. Stay with the beneficiary. No, that's all. Thank you.
That's why I say it might be easier to prove trust on a public trust than anything else because it's publicly known. It's a given.
Right. Except most people don't see it that way. They just assume it's something, just a statute.
Yeah, because they're not really looking at it through trust eyes.
Right.
There's a confidence that we, the people, have put in the officials as trustee for the people's benefit.
Now, now since I'm coming in as a beneficiary, I don't have to worry about CCIs?
Not so much on a public trust. Just have to worry about putting the records in to prove the trust and the breach of the trust.
Right. It would be, we assume that what you used to say is a public trust, so let's assume it's a public trust, but we have to prove the breach.
Right.
Okay.
And then attack it on as a trust.
Right. Okay. Thank you.
Which comes back to that corpus juris secundum I keep on talking about last couple of days or so that reinforces what I've said all along, that he who claims trust must prove trust, and you're going to prove trust by a trust. And that corpus juris secundum said that under the general heading under section 161, the rule of construction, it is a rule of equity that once a trust is created, it is thereafter to be treated as a trust. If we don't treat it anything other than a trust, say debtor-creditor, then that's our major problem. I think that's the whole thing in a nutshell. Can't attack trust with debtor-creditor.
Right. So my first move would be to gather evidence of breach of trust. And would that be based upon their statutory regulations or just based stuff like failed schools and low tests?
Yeah, that might be an interesting thing, yeah.
Okay.
Now we're starting to do government.
Yeah. Yeah, we're going to do government, right. But we'll see how far it goes. But I would still send them, I would still use stuff like registered mail.
Yeah, you're creating records, creating titles, and then those records are going to be used to prove your claim.
Would I have
the trust? Then the trustee is presumed to be guilty, and now the onus probandi shifted to him, and he's between a rock and a hard spot then.
So now, what should I ask? I mean, in a practical sense, it's not about the money; it's about improving the educational system.
Yeah, well, that's what the Court of Equity is going to compel them to do the performance.
Can I give instructions as to how I see it should be?
Yeah, there may be some indentures like the statutes and codes that would say such and such a thing has to be done or whatever it is. It might involve some research in there.
I mean, like the way it is now, because I mean, I teach on a daily basis, and the way it is now, the system makes the kids come to the system, and the system's out of step with time, and the kids don't like what, it's in an effective way. But if we do it, if we change it around where they have more practical, real life learning, from my experience, they learn easier and they're happier. They want to learn. So that's my basic purpose, is to make a shift in the way it's done, because a lot of subjects are not, life specific. So my question is,
the remedy is what you're getting at is all through the past history we've been trying to change things by doing the debtor-creditor realm, and it was ineffective against the trust.
Mm-hmm.
So if we start getting the trust mentality and start changing things by trust against the trust, then maybe we will be a whole lot more effective.
So then I could write up sort of like an indenture or instruction list to the beneficiaries as trustee, recommendations or commands, rather, what I want them to do.
Possibly, yes, because the indenture would be probably the statutes and codes somewhere, how education is supposed to be run.
Mm-hmm.
You could come in and, since things are failing, that indenture needs to be modified some way.
Oh, I got you. Right. Yes, I could modify the trust as a beneficiary.
You could put in a suggestion, I think it takes a consensus of all the beneficiaries to modify the trust, but at least you start making a stab and getting some people involved behind you and start attacking this as a beneficiary trust and start changing things by trust instead of statutes and code debtor-creditor.
Right. So that's the key factor, is like naming the beneficiaries, and there's so many thousands of people involved. Consensus might be a challenge.
Yeah, but it starts with the first domino.
Okay.
And you never know, the momentum may grow.
Well, in New Jersey right now, it's right, because the governor is cutting back on education and all that kind of stuff. So,
I think back in TT last November when we first announced it, and I look back, say, 6 months now, how phenomenal this has grown. You would not believe. You would not believe. It's really awesome, really. I mean, we had on the website, we had 152,000 downloads in 1 month.
It's a lot of people.
That's a lot of people. Somebody's taking this in. And I'm hearing through the grapevines, people are picking this up, and I'm hearing different things that people are doing, and I'm hearing some success stories at it also.
That's good.
Anyway.
Okay, well, thanks for the input. I'll keep you posted. Okay,
I was reading Secundum on page 166, where it was saying that a piece of paper never ceases to be the property of the issuer. A piece of paper never ceases to be the property of the issuer. Now, that was under the section under bills and notes. But bills and notes is under commerce, and commerce is the public. And since we're operating in this commerce, this public, the fact is that your signature on all these documents that put everything into play, and you're the issuer, and that paper never ceases to be yours. But we're never asking for the signatures or the pieces of paper back, because we're always not expressing a trust as a special deposit. Our signatures are special deposits, but we're never expressing that. So consequently, they're being construed as general deposits. And
debtor creditor.
Yes, as I was talking in the other corpus juris secundum, was that it said that under a general deposit, that sets up the relationship of debtor creditor.
Okay, now you say that. I mean, okay, so now if the paper is never out of the ownership of the issuer, then I mean, if I is approaching as a beneficiary, how is that something I could? I mean, how is that going to benefit me? Because only the grantor is going to give directions for a special deposit, right?
Yes, but then it could be maybe even the trustee can make a special deposit from the trust.
From the beneficiary's commands?
It's ultimately for the benefit of the beneficiary anyway.
Right, but I'm just saying the rights of the beneficiary can compel or command the trustee to make a special deposit as if you were the grantor as well. Saying
that's if the res was specified, or I mean the indenture, excuse me. The indenture was specified that the beneficiary had some rights reserved for him, yes.
Yeah, but on the other hand, we can modify the trust to stipulate that.
Yeah, you can. Yep. But the point is, I'm asking for our deposits back. We're not expressing that they were special deposits. We're trying to get them back under debtor creditor. We're not giving them back under debtor creditor because they don't have to under debtor creditor.
I got it.
Although this thing is really saying that you do have, because this is debtor creditor.
So if I send paperwork over to the trustee as a special deposit, a request that they make, or a command for special deposit, then it's a similar effect as if I were doing it as a grantor.
If you expressed it to be a trust, yes.
Yes.
Had the evidence that it was a special deposit.
And then I have to do the UCC1, right?
Yeah, the 1 to 3 and the 3s, yeah.
Right, okay. So in a way, we can use, it's the same process, but from a different perspective.
Yeah.
And my modification, I'm sorry, go ahead.
Pretty basic, but, it applies to everything.
So the indenture would be the modification.
You could indenture modify it, yes.
And the indenture would be the paperwork.
Yeah, or you could just issue a callback of the, order the surrender of the documentation or the deposit. Order it back. Order the surrender.
Of the indenture.
Yes, under certain circumstances. I don't know about the public trust here, but say another type of trust, any other regular type of trust, order the surrender of the note back, or order the surrender of the res back, or because it was put under special deposit.
Right.
And if they didn't return the special deposit, then they would be in breach.
Oh, I got you, right. Set them up for breach, right. Yeah, that might be the easiest way to go, because normally they wouldn't respond because they would consider it, not relevant.
I was thinking more along the lines of debtor creditor pieces of driver's licenses, different documents like these, birth certificate.
I got you. Okay.
Anybody who is the issuer or the signator on the documents has got the right to call them back because those documents are yours.
Mm-hmm. Right. Well, this is it's a different thing. This is a different trust.
Yeah, but the principal is still a special deposit, and a special deposit is supposed to be returned in kind. If it's not, it's commingled, and then it's a breach. All trust basically going to work the same way.
So then, as a beneficiary, I could command them to keep it for so many days and return it. And if they fail to do so, it's a breach of trust.
Yes, if you had that right on that public trust. I don't know if you do have that right, because it might not have been written into the indenture.
Oh, that's true. Right.
The indenture has all this 50 titles of all the USC say. Then, that's a lot of code.
Yeah, it's true.
I don't know where you're going to look to find out specifically where you got that right.
Well,
but if it was written in there someplace and you found it, then as beneficiary, if it was given to you per that indenture, then you can do it.
Or I could just say that I have the right and let them disprove it.
Possibly. So I'm thinking about that. If you can prove that you're the beneficiary, you could make the claim. Then if the claim it's up to the trustee to prove whether or not you did what you were claiming, or you didn't do what you were claiming.
That's what I'm saying.
But he's still got to prove it first, doesn't he?
Yeah, he would have to. Yeah, because it's going to shift back to him for the breach, and the court eventually will assume that he's in breach.
Yeah, I was unclean hands.
Yes, but if you could come up with some kind of certification of a breach of the public trust, then you got some kind of grounds to come at him with.
Well, low test scores, failing schools, a command to correct, and special deposit, so many days to correct.
Yeah, who would know what the court judge would do? You'd have to make the claimancy.
I'm sorry?
The judge. The judge is going to be the one that's going to be enforcing equity.
Yes. So once again, like you said, I have to research to see if I have the right to make the claim.
Well, I think you do, because you're part of the public. You're the beneficiary. So that's pretty easy to prove that you're a beneficiary on a public trust.
Right.
Just create the records of a breach according to some breach of some statute and code, like you said, on something under the public educational system that didn't. That was breached, that this school is failing.
Right.
Who knows, when you start peeling this can of sardine top off, what's going to be revealed, and it's going to probably morph in its own self along the way, and you'll be able to see as you go, as you unwind the top, which way is going to be the path.
Right. Well, my first thought was, I wasn't sure about the res, so I see now that I wasn't, I have a different way of doing it. I was doing it the other way, which is not going to be effective. So that's why I asked the question.
Right.
Well, it was a good one. Thanks.
All right.
Peace.
I'm going through corpus juris secundum, and I'm coming across different things in there. And another one I was in the book on parties, 7A, book 67A, under section 112, which is the name description of parties, under section 112 in general, it talks about the beneficial owner. It says, in an action at law, by the holder of the legal title, it is not necessary to give the name of the equitable owner. The equitable owner. And a trustee plaintiff need not state the name of the beneficiary. I think we're doing things possibly wrong when we're coming in and claiming that we're the beneficial holders or the beneficial party in interest. I don't think we have to make that claim. Going by what this says here, that in an action at law by the holder of the legal title, that would be the trustee, it is not necessary to give the name of the equitable owner. And that equitable owner, that's the beneficiary or the beneficial interest title holder. And the trustee, that's the one holding the legal title, the trustee plaintiff need not state the name of the beneficiary. It's not necessary. But in a court scenario, when you ask the judge, why are you taking my name? One thing you could say, I know for a fact, Judge, that you are not the beneficiary because I am the trustee on this trust, and I know who the beneficiary is, and that beneficiary is not you. So you have no right to take from this trust because this trust is private.
But Christian, remember last time we talked about putting the paperwork in first, so we wouldn't have to have that conversation in court.
Uh-huh.
So now I assume this is like just like a formality in court, but we've already sent the paperwork in, right? That makes that claim that the court is not the trustee and that there is a beneficiary, but we're not compelled to name the beneficiary and that we're the trustees.
Right. So I'm seeing that we should probably be coming into court as trustee on the public side, but in reality, on the private side, we're beneficiary. And I really don't need to name that beneficiary because that's private.
And then that would be the portal going to chambers, right?
If necessary, yes, I could reveal it there, but it might not even be necessary there.
So what I mean is that
I'm trustee on the public side. I'm making a claim to this trust. I don't have to reveal the beneficiary.
No, and you say because it's a private matter, that I'm thinking the court would say, well, what is that? You would say, well, no, I can only reveal that in chambers.
Yes, if it came down to that, yes.
Yeah, that's what I meant.
I think you probably can't be compelled to reveal who the beneficiary is, and we probably shouldn't be revealing who the beneficiary is because it's really not necessary. The trustee is the one who's making the claim. He's making it on behalf of the beneficiary anyway. And if you prove trust as trustee, trustee's got the right to make a claim. He's got the right to defend the trust, even though it's a public trust or, say, it's a private trust. Is Shane out there tonight?
Yes.
Hello, yes, Christian. Hello.
Yeah, hello.
My name is Lee, and I had talked with you once before in reference to a closed criminal case that I have, and I wanted to get it completely knocked off of my record and everything, and you had begun to tell me about a couple of things, and I just wanted to get clarification on a few questions. If you could answer those for me, I'd appreciate it. What I wanted to know was, what would I put on the NOI? What would go on the NOI and the SOI in terms of what the revs would be in terms of to have this process transferred to the asset title? What would I need to put on the NOI and SOI?
Well, your signature is the trust res, and everything you put your signature on, which would be all the documentation that they used to charge you with, that was all a special deposit, and you need to order your special deposits back. They must return the original documents, and they have to give you back all the proceeds therefrom.
Okay.
So everything that was generated.
So everything they're charging me with. Go ahead. No, I'm sorry. Go ahead.
Everything they're charging you with that your signature generated, and everything connected with it is all yours.
Okay.
It's all a special deposit as a trust. Now you need to order the special deposit back.
So the information that would go, I'm just trying to get a clarification. The actual information that I would put on the NOI and SOI is basically...
The NOI is plain, but you're talking about an NOI and an SOI. Say, like in a breach situation, the breach would be the breach of trust. That would be the NOI. That's the claim. And now what the SOI is the material fact to support the breach. Where's the evidence that they breached? The evidence would be that I demanded the special deposit back, gave them a specified amount of time. They didn't do it. The notary certified anonymous response generated a certificate, and that certificate is your record that they breached. There was no response back to the special deposit return order.
Okay. Now, like I said, this case is closed and it's over with, but it's still on my records. So, and it will still come up.
You just said it right there. Well, you just said it. Say it again.
The case is closed and it's on my record, and I want to get it off completely.
Right there. Stop right there. Do you realize what you said?
Okay, no, explain it to me. I'm overlooking it, obviously.
The case is closed. And
Yeah.
what was the next part?
The case is closed, and I want to get it off my record. It's still there.
Oh, stop right
Still
there. What was the second
Okay.
part? What was
It's
the
still
second
on
part
my
again?
record.
Say again?
It's closed, but it's still on my record, and I want to get it off.
Not the first part, the last part. That's the key part. Do you realize what you're saying?
In other words, it's closed, so it should not still be there. Is that what you're saying?
The first part is it's closed. The second part. What was the second part again?
And I want to get it off my record.
Whose record?
My record.
Your record.
Yes.
So it's yours.
Okay. I see what you. Okay.
Is it not yours?
Yes, it is. It is.
Why'd you give it to them? Why don't you ask for it back?
Okay.
The definition of give in Black's Law, where's my sheets at? In some other book. Definition of give in Black's Law. To voluntarily transfer property to another without compensation. Why'd you give them your records?
Okay, I see what you're saying. Okay.
You voluntarily transferred property to another without compensation. But since you didn't do it under a special deposit, it was a general deposit, and a general deposit puts you right under debtor-creditor. Now just come back and correct the misconstruement and ask for your special deposit back because it's my records.
Okay. Now, I understand all of what you're saying, but how do I go about asking for it back? That's my question. So that's what I need to know exactly.
Well, you need
how
to
go about doing it.
You need to pick up an order of surrender of the original special deposit order.
Okay. An order of surrender.
Yep. Surrender of the original documents and all proceeds therefrom. But first, you'd have to have the evidence that your signatures and everything were trust res and special deposits.
Okay.
So that you could claim trust. But then once you claim the trust, got the records that you made special deposit, you got trust res, then order it back. You need an order, ordering it back. Order the surrender of the special deposit.
Order the surrender of. Okay. So
do that by a notary presentment. Do that by a notary presentment. Have the notary present the documentation. And if they don't respond back, have that notary, in 14 days or 30 days, whatever, certify a default or dishonor, have him certified under his hand and seal. And that public document that he's going to generate is going to be your record. And then you can put the notification on a 1 claiming it. And that becomes part of your trust also.
Right.
And then that would be the certification, the non-response by the notary that was the breach of the trust.
Okay. Now, so doing the notary presentment and give them 14 days to respond, and if they don't respond, that's a default. Okay. So, and then I order the order of surrender of the original document. But here's what I want to know. Here's what
presenting the order to surrender and giving them the order. And when they don't do what they're ordered to do, then he's going to certify they didn't do what you asked them to do.
Okay.
He's going to certify that he got no response back from them.
Okay. So the fact that if I get no response back, then they're already in breach. They're already...
Because the notary non-response would be the breach that they did not respond, did not return back what you ordered them, and therefore they're in a dishonor. They breached the trust. Then I would send them out a notice of a breach of the trust, and really that's like 3-305 under UCC, notice of a claim. And then you just do basic government due process, notifying all parties, and then you come in with a cause of action for breach of trust.
Okay. Now, would I need to file a UCC3 in order to have that title completely transferred to an asset title after these steps are done?
Well, in this particular case, you might not need to have an asset title generated to merge any kind of titles, because all I want to do is when I get my documentation back, which contains my signature and everything that proceeds from it, that's going to suck all the information that they are having out of their hands. What's left?
Okay.
Did you just expunge the record?
Well, that's what I want to... Right. That's what I...
If they give you everything back, even the duplicates, they can't keep any duplicates because those are the proceeds thereof.
Okay.
When they give you everything back, there should be no record.
Okay. So everything should be basically expunged.
Yeah. Okay. Or else there's going to be a breach of the trust. You're probably going to have to go into court and, take the fire to their side so that they're going to be forced into doing what they're supposed to be doing, which was Court of Equity going to compel them to give you all your records back.
Okay, so you're saying I probably will have to go into court with all
Yes,
of these.
because I don't think any people just give up and say, okay, here you are, really. Not till we start teaching them who we are.
Okay. All right.
If they're the servants of government, we're the grantors, they got to be doing what the creators of government are supposed to be instructed to be doing, serving the creators.
So basically, it could be a long, drawn-out process if I would have to go to court. That's what you're saying?
Possibly, yeah. It might take 2 years. Yeah.
Now, I have another question. So basically, doing all the paperwork with the notary presentment and everything, and the order of surrender and all of that. Basically, once all that's sent in, then I'll know at that point if I'm going to have to take it further and go into court and fight with them on that level. So I really wouldn't know that until I do all the...
Yeah, but I wouldn't count on it. Yeah. I wouldn't count on them. They're not going to do it without a fight.
Okay.
I'd prepare for the worst and be prepared to do that if not. So weigh that in the scales which way you want to go.
Okay. Now I got a question. You have an ambassador group?
Yes.
Okay. How can you become a part of that?
Do you know anybody that is an ambassador?
No, not offhand. No.
You could join the Monday night call. It's at 10 o'clock. It's the same PIN number as this one. And then just ask for who's a trust ambassador that you can get up under. And
trust ambassador. Okay. All right, and they would be able to assign me someone then and tell me what to do.
Yeah, I try to have my 12 and those 12 and everybody else is under those 12.
Okay.
I don't have time on everybody, so I'm just picking my 12. And
okay. So just call on Monday night and ask to get up under a trust ambassador.
Yes. Mm-hmm.
Okay. Okay. Well, thank you very much.
Sure. Appreciate it. Thanks.
Bye-bye.
Is Shane on the call tonight? Shane, you out there?
Yeah. Hey, Christian.
Hey,
can you hear me?
Did we make some headway last night? I'm not sure if it was clear in your mind. We were talking about the beneficiary and the trustee and about the equitable titles and the legal titles and stuff.
I always spread myself.
I want to make sure that was clear in your mind, so we got that set. So,
what's kind of interesting. I mean, even today you're saying that you are kind of moving a little bit away from saying that you have to be the beneficiary, right? So I try to keep myself
on the public side.
Well, that's actually, yeah, well, you're actually saying that. I was going to ask the question then. So you're saying that you can be the trustee then on the public side, and in essence, you're representing the beneficiary on the private side?
Yeah. Hey, that's what you're doing.
That's possible then. That's okay. Well, that's a very cool insight for me right off the bat. See, for me, I'm always trying to be ready to keep open for the next thing coming around the corner, right? Because I'm trying to ever expand a more comprehensive understanding. I try to avoid just, by rote definition of stuff. So sometimes I have moments of great focus, and spread out between long runs of things being kind of messed up, but not in the same way that other people are messed up, so to speak. I hope that makes sense.
But I wanted to ask you, is it clear in your mind now that you see the positions between the beneficiary and trustee and the two types of titles? Is that clear in your mind?
Okay. I could very much go over that, and the best way is I wouldn't mind one example of, because we were talking about two things. One was an example like where somebody owns a vehicle, for example. That'd be a nice, easy one for everybody to get. And then there was the issue of the birth certificate itself, right? That's what we were kind of discussing last night. That's what you're making reference to?
Well, I don't know. I don't think I was making a comparison to any specific example. It was just that there's only two types of titles. The trust came in and split the perfect title, which was just one title, a allodial title or perfect title. The trust came in, and the trust purpose is to split the title. And it splits the title into possessory title, which is the liability title, and that's in the trustee. That's the legal title. And then the other one, that's the 9/10 one. And then the other title is in the beneficiary. That's the 1/10, which is the real ownership, really. And that's the beneficial interest or the equitable title. And that's in the beneficiary.
Okay. And then you made another interesting point just today as well, saying, for example, that whoever issues the paper will always remain the owner of it. Okay.
Right. And that was under debt of creditor.
Okay, that would be that could be construed as debt of credit or trust, right?
Yes, I would think so. Yeah, because that was under bills and notes.
Okay. Now, because I come from Vic and different points of view and stuff, and I'm really coming from Winston and all that stuff. But who do you consider issues the birth certificate? That's the government, right?
Nope.
No? Okay. Nope. There's where I'm maybe having a little bit of confusion in. So
the fiction is dead. The government is the fiction. How can the fiction do anything unless it's got a charge by a live man or a woman? There has to be a signature charging something, ordering something.
Okay, so that comes back to me then.
Somewhere I connect back. I'll say that the government was the mechanism to create the birth certificate, but it was not given the order by itself. Somebody had to order it. And a real live man or woman had to order the birth certificate. And whoever put their signature on is the grantor of the birth certificate, the issuer of it.
Right. Okay. That's clarifying. And then, and so there they go back to being the beneficial, the beneficiary in that trust relationship.
Let's just stop right there. Let's just say, okay, we ask documents back and they never give them back to us. Why don't they give us the original ones and things? Because we didn't express it to be a trust, and we made a general deposit, and we gave it to them, and we, by definition of give, we voluntarily transferred property to them without compensation.
Would that be one way to? I was talking to another gentleman, and he said that he actually has possession of his original, the document that has the footprints. I think he calls it the record of birth.
Right, live birth, yeah.
And he says that's an important one to have, I think, because of some story with his mom, and she kept it for sentimental reasons or something like that. So actually, by expressing the trust, would that be a means of putting a lot more teeth into trying to get that document into your possession?
Yeah, because if I expressed it that was a special deposit done under trust, then what I gave you, I got to get back.
There you go.
It's going to be a trust.
Okay. That's pretty cool. There's, I learned something almost every minute.
All the other proceeds that was generated from it. All the other copies you got in there.
Well, that's a whole other story. I try and get the possession of that back and just to see it in my hands first. But I'd certainly follow that up.
If I get my special deposit back, then that should close down the whole account, because really, what's left? If everything that generated from that is also mine, and you give it all back to me, then if I check some other time after that, there should be no record left.
Well, you know what? Interesting that you bring that up. I've gone around because I try to keep track of my social insurance, and I never really gave it to the bank because I heard that story on the radio. And just incidentally, like totally innocently, I used to walk in the bank and say, you know, I heard something on the radio. The government was basically giving people heck for using their social insurance as ID. So I was aware of that when I walked into the bank, and my story is quite simple. She asked for the SIN, and I said, well, I thought we're not supposed to be using that. And she kind of giggled, and then she said, well, she proceeded to ask me again, and then I explained to her, I said, you know, I just heard on the radio and the government's actually saying, you know, just because I want to get her opinion, like what's going on, right? They're supposed to be the bank of high standards, et cetera. And then she giggled, and she had admitted that they just are told that they try to ask for it, but you're not really obligated to give it. So ever since then, that's one story in itself. But ever since then, I always go to all the banks and I say, I know some of them I didn't give it to, but I lost track. So I just go around to all of them and I say, I didn't give you my social insurance, did I? And if they have it, I say, well, then if you have it, I don't recall giving that to you. And I need you to remove it. And I do notice that they all remove it. And I go in and I check sometimes, right? And they actually have it removed. So that sounds like a trust thing going on there again, doesn't it?
Yeah. But did they give it back to you?
Well, I just requested that they remove it.
Okay, but you didn't get it back, though. They still got it.
Like on a piece of paper, you mean? It's because I'm talking more about the information itself, right? I didn't give them my SIM card per se, but it was the information.
Well, I'd like to know how they got it. They must have got it. They stole it then. But if they stole it, they still want it back. Did you get it back?
How do you mean now? Besides the information being removed from the record, you mean like a note of record of their action?
Yeah, they gave you the record back.
Well, it's just in a computer.
If they didn't give you the record back, then you didn't get it back.
So that would be like a proof or receipt or something?
Yes, they should have signed something that you got it. They should have asked you for a receipt after they gave it to you. Hey, you guys are in breach. You didn't give me back what I asked for. As far as I know, you stole it. I never gave it to you. You stole it.
So I need on black and white in the form of some kind of a note or record, an acknowledgement that a request was made to have the social insurance removed, and they have in fact done that.
Right.
That would be the thing they could give me. Okay. And just for the purpose of having a proof of record.
Mm-hmm.
Okay. I think I got you. All right. Okay.
Hey, Christian, it's Jason. I have a question for you.
Yeah, go ahead.
Shane, if you're done.
Yeah, no, I'm full right now.
No, I'm still going to ask him about the equity thing, so if you could clear on the time.
Okay, go ahead.
Well, my question was, it's a bit of a paradigm shift. I mean, we've always had the choice to come in as trustee or grantor beneficiary standing in open court. But the issue, it always seemed, in a sense, more protective to come in as the beneficiary after you've made a claim and with your proof of the trust that you can send to the judge in chambers. So if we're going to change the paradigm, and now we're going to focus some of our energy on coming as trustee, then they're going to do what they've always done. They've always construed us as a trustee and wondering why we have failed to make payments. And now we have to state that, yes, we have failed to make payment, but for cause. And now I think the burden is still with their trustee to demonstrate why we've to make
well,
that. So
if I was a trustee, why didn't I make a payment by my special deposit?
think I see where you're going there.
You broke up a little bit, Christian. I'm sorry.
I was going to say, if we were the trustee and they're claiming that I didn't make a payment, well then, where's my special deposit? Because my special deposit made the payment.
So we just have to make some type of special deposit and make that record of it, and then probably move for either protective order or move for in-chambers camera review of those documents demonstrating proof of payment. And is not coming in and claiming that you're the trustee for this matter, is that not also a breach of trust, public trust? Is that non-colorable?
Well, that'd be the next thing. We might have to figure that out. Say, if we want to treat it that way colorably, or we want to keep it as CPI information that I am the trustee on this trust.
Because somehow they're going to want to know the name. They're going to know who you are. What authority do you have to come in there? Whether you're as a trustee, beneficiary, authorized agent, living man, whoever you are, they just want to be able to know who they're talking to, who's doing business today, who's coming in to do business to settle this account.
That account, so, which is the case, I took that account that was the case, and I treated it as a trust, and we're forming the trust right then and there, and I am the trustee on this account, this case. And that case,
in the public,
got into the special deposit that made the payment, and there's where your record of your payment is.
I can see a lot of responses being something like, "Oh well, Judge, if you didn't know or understand that a payment was made in this, it's not my duty to teach you the law." They're not going to know or understand that a payment was made. They're going to look at the paperwork they get in chambers and wonder what this patriot mumbo jumbo is. And
well, I guess we're going to have to educate them on the fact then.
Yeah, and
and show them that, hey, it's
and of
not
course you make that in the form of a question.
Using the same rules that they use against us.
Yep. But wouldn't some of that information wouldn't that all be in paperwork first? I mean, they would have had a chance to review.
Well, I don't know. We've talked to some people about, in fact, they've been on the shows and things that they've said that all they did was oral stuff.
Yeah, exactly. So there's got to be something.
I think I'm going to need that tomorrow because I couldn't figure out how to get my online filings done.
Well, I think it's ideal to have your paperwork in the background. I think it's ideal to be able to send to the judge in advance some evidence of the trust, some evidence of the claim, and maybe even your authority, not necessarily authority, but who you are. And I come back to the matter of changing our jurisdiction or changing the venue in which we're operating, so that we are now coming in a different capacity, not just as a clear differentiation between the straw man and between the living man.
Yeah, remember you can make an NOI that's not substantiated by an SOI material fact, but you've got a little bit of time in there before that thing's going to time out. As long as you come in with SOI to support that NOI within the 30 days, then your claim's going to be substantiated.
So question, so if I go online and I do an online filing tonight and I print it off of the screen, my filing, even though it's not certified, then I can bring that and that's my NOI.
Yeah, there's your presumption breaker.
Okay.
Or that sets up prima facie evidence at least, because now you got copies of originals. That's all they do.
Okay. Well, then I know what I got to do tonight.
Hey, Eric, did you get that document out there? Pass it around?
Say it again?
Did you get that document out there? Maybe pass it around. I'd like to get some feedback on it.
Among a group that I'm currently involved with, yes, but we'll get to that sometime soon, hopefully.
All right.
Christian?
Yes.
Is there when you're talking about the stuff with Shane about the beneficiary,
Right.
if you go to the other side, like the grantor, there's a grantor, a trustor, and a settlor. When I think of the word grant, I think this kind of a grantor, he's going to grant something. When I think of
really they're all the same. Settler by Black's Law definition is, I like that one because it says that party has an interest in the matter. But they're really all the same. They're synonymous. They're all creators.
Identical?
Yes. Uh-huh.
Are they identical to each other?
Yes, they're synonymous terms. Grantor, trustor, what's some a settlor. They're all synonymous terms.
As an example, the grantor, the word grant, has the word grant in it. Settler,
I think what you're alluding to is, what I like to do. I would like to use grantor if I'm forming the trust. Then if I've got a problem, I want to reform the trust or correct a misconstruement, I'm going to come in as settler.
Okay.
Yeah, reform, right. And what about trustor, creator?
Yeah, that's synonymous with the other terms also. That's creator also, yeah. But I like grantor or settler, and I would use those two terms myself a little bit differently because I understand them a little more. So it sounds like you're coming in to settle the matter.
Yeah.
Grantor is coming back in to form something or grant it or give it, start it off. Use it. That's how I would use it. But all three of those terms, they're all synonymous and they could all work for the same thing.
Well, the reason why I brought it up is because do you think is it possible the same thing could exist for a beneficiary?
Don't know. I've never heard anything used other than city key and beneficiary or beneficial interest, something like that.
It seems like the major...
You could use grantor as also creator, same thing. Creator, settler, grantor, trustor, those are all synonymous terms.
As an example, say you have an income beneficiary or a remainder beneficiary.
They're beneficiaries, but then they're reserved for certain kind of trust res, and it's split up.
Certain kind of purpose?
Yeah, because the income beneficiary, he gets like the payments for his life use. And then after he dies, his remainder beneficiary may be his heirs, the tail.
Mm-hmm.
How long do you have to do that for? 3 years?
How long?
Yeah. Is there like a limit to after somebody dies?
Well, now who would die? Did they say the beneficiary with the beneficial income?
Yeah. Like you said, there was
I don't know how that would make any difference because the grantor has already established everything that's supposed to happen.
What if nothing was established? Like most people die.
Yeah, that's probably the problem. They don't have any trust.
But then can you not construe or express a trust at that point, especially if you're like a family member or something?
Yeah, if you've got evidence that you were receiving income and you had some kind of evidence that as Just death of
if it's like the head of
income.
if it's the head of the family, then like the wife would have something.
Yes, right. She could be the heir of the principal after the husband sees beneficial income.
And then she'd probably need me as a trustee or something like that to do it on her behalf in this case.
Well, there would have to be a trustee already.
Well, somewhere.
Still income. It has to be coming through a trustee already.
I've heard that there's money in after that when people die, especially, everybody, right? There's some kind of person.
If you stay in the vein of thought of grantor, trustor, settlor, and then you think in the vein of thought of income beneficiary, remainder beneficiary, heir 1 through 20. Now, is it possible that the trustee could have there's different kinds of trustees?
Sure. It's got to be.
Co-trustees, yeah.
Well, co-trustees or trustee agent?
Well, the agent would be different. He would be working on behalf of the trustee with certain kind of limited powers granted to him by the trustee.
And as an attorney in fact? Or would need an attorney in fact do that?
Right.
So there's trustee, co-trustee, and trustee agent on behalf with an attorney in fact.
Yeah, you could look at it that way.
Okay, I'm trying to see how many different actually scenarios you've got to.
But now they can only what powers they have themselves set by the indenture.
Mm-hmm. Unless there is no indenture.
Right, and then it would have to be full evidence, say, out of the mouth of the grantor or some other witness.
Oral.
And that would leave the court with tremendous latitude to construe or misconstrue.
Now, in court, when you want to settle something, it has to be trustee to trustee to make an order to discharge the public debt?
So you just got to request some kind of claim to be brought forward?
Somebody could be breaching the trust and they're not a trustee. So the trustee in charge that's being breached would have to bring a claim against whatever party that is breaching or attempting to breach the trust.
I was thinking I'm sorry, I didn't get the context, but I was thinking in the context of a traffic ticket. You go into court, you're the trustee, the judge is the trustee, you got to give them an order, trustee to trustee, to extinguish or discharge in the public the charge for the ticket.
Well, why assume you understand what process they're saying?
Trust the point of view you're coming from. Are you trying to say that these are agents of the U.S. Trust, which is the City Key Trust that they're all trying to get into, or are you forming a trust locally in the court there and you're pointing to the trustee?
Judge would be the trustee for the U.S. You're the trustee for the City Key Trust, and you want to order a discharge on the presentment that's that's there for discussion.
Yeah, extinguishment of the debt.
Right, for the extinguishment of the debt. So it would be trustee to trustee in a ticket matter, right?
Yeah, but we're talking trustee, judge being also two trustees, really. He's trustee of the United States, and he's trustee that you appointed him trustee of. So he's got two trustee positions.
And so that goes back to what I was just talking about, the different kinds of trustees. There's trustee, co-trustee, and trustee agent on behalf of attorney in fact. Now, is there another trustee when you've got two trustees together in the same person?
But he would probably never claim that he was U.S. trustee. Or
no, but he would act like
U.S. bankruptcy. That would be too much truth. He wouldn't admit that.
So he would just act as the trustee for the court to.
Yeah, and then he may try and disclaim that he's not trustee or your trust.
Well, but if you give him an order to extinguish the
Hey, wait a minute.
Yeah, right, but he can still disclaim.
What about appointment?
What about what?
So,
The trustee position. Fiduciary trustee appointment.
Yeah, you could use a fiduciary appointment. Fiduciary is nothing more than a trustee. But he can still disclaim.
But that's at his dishonor, though.
No, it's not a dishonor. A resulting trust forms when he disclaims, and now that actually puts you in a worse position, because now as a judge sitting on the bench, he can't let the trust fail for a lack of trustee, so he must form a resulting trust and then hold the trust res in a resulting trust until he forms or appoints a successor trustee. And then I would be telling him that when you appoint a successor trustee, be sure you tell me his name and address so I can deliver trust res to him, because it'll probably result or revert back to me, and I'm going to be temporary trustee holding trust res until he appoints the new trustee, successor trustee, and I could give this new trustee trust res to complete the trust. Otherwise, he would be in breach of the bench and a worse position if he just accepted the party as trustee.
You're saying essentially he's trying to take it away from you, but you're going to try and go back in there and say, I want to get that specific information. Should you disclaim and try and pass that on to creating a resulting trust?
Yes, temporarily a resulting trust is formed, and I'm going to be the trustee on that temporarily as grantor, holding on to the trust res until he is disclaimed, but he's got to reappoint a new successor.
And it's at that point where you're losing control and he's taking it away from you?
No, he's not taking control away from me. He can't. There's no way he can.
Well, I thought you were saying that he's disclaiming it and then creating a resulting trust.
Yes, but that's what happens. When you're in court, a court of equity will not allow a trust to fail for a lack of trustee. The court must appoint a successor trustee, and a resulting trust is formed until the successor is named. And temporarily, the property res reverts back to the grantor that he holds temporarily until he learns who the new successor trustee is, so that he can transfer trust res to him and complete the trust, because the trust cannot be allowed to fail.
Okay,
now, if the judge does not appoint a successor trustee, he is in breach of the bench.
Okay, so this is a good example of a resulting trustee, a resulting trust in this case, for sure.
Right. But the big thing is, if he doesn't appoint a successor trustee, and I would tell him within a time limit, you got 30 days, otherwise you will be in breach of the bench.
Wow.
And you will never work again as a judge.
So he's only bought himself 30 days then?
Yes.
You could even say less time if you want, like 7 days or 3 days, or?
I suppose so, but everything's in court's done usually, in 30 days.
But Christian, I thought that public officials like judges and district attorneys were held to accept trusteeship.
That's under 7702, I think, of IRSC code, that you're all employees of the U.S.
So
this is under trust. This is under trust.
So it doesn't apply in that case, in trust?
No, under trust, they got a right to disclaim.
Okay, thank you.
But what I'm saying is, under trust, that's worse yet, because if he's a judge, he's in a worse position. Either he lets the trust fail and never works again, or else he appoints a successor trustee. You see how much power that is?
Yeah.
Well, there's not a name for when one of the three parties fails.
Failure?
Hey, Christian.
For the three parties.
Well, if the beneficiary fails to carry out an order, does he get a different kind of name for beneficiary, like a failed beneficiary, or?
Beneficiary doesn't carry out an order. He has no duty to perform and do anything.
Excuse me. I mean.
Beneficiary doesn't have to be competent. Only the administrator or the trustee has to be competent.
I meant
He's
like
the only one with the duty.
I'm sorry, but I meant like if the bank was the trustee and the beneficiary at the same time.
Which they can't be.
Yeah, the trust would terminate.
That's what I'm saying. If he didn't terminate the trust and you appointed him as the trustee and the trust didn't terminate, would he get a different kind of a...
If the trust didn't terminate?
No, you'd come at him as for the trustee. Trustee is supposed to wind up the trust and terminate the trust and disperse the funds.
Yeah, and if he doesn't?
It's the trustee's fault.
Breach of trust.
Right. So is he still the trustee if he fails at his job?
If he breaches the trust?
Yeah, he would be breach of trustee position, yes. He didn't complete the obligation.
Yeah, breach of trustee?
Sorry, what's the name of this game again?
Breach of trust.
Or euchre.
Hey, Christian, here's a thought. Going back in some of our other comrades out there, when a public defender fails in a case, he is failing the trust before you're the grantor and he's a trustee, and so therefore when he fails the trust, he's liable for the damages that have accrued for the grantor.
Yeah, on the public trust.
That's right. So you can nail that public defender or whomever, and this is for you, Eric, you can nail them for breaching the trust, which would be the intent of the grantor settler for the outcome to be positive in the nature for the grantor and settler.
Is that where the breach of trust is? I mean, didn't he provide a beneficial service and wasn't a benefit received?
Yeah, but
was it under the statutes and codes that he was supposed to be a public defender? Well, that would be a breach of the public trust then.
That would be, yeah.
He's obligated to win by trust, you're saying?
You bet.
Yeah, statute and code. If he doesn't do a statute and code satisfactory, that he'd be in breach of the public trust.
And you'd have to be a better lawyer. You'd have to be a better lawyer than him to be able to prove that.
I don't have to prove anything. If I'm the beneficiary, all I got to do is make the claim.
Okay.
Onus of probandi shifts against him, and the assumption is that he breached.
So what would you be putting would you be doing UCC 1 and 3 on the court case?
Yeah, you could bring that in, yeah.
You can do that.
Motion to reconsider, bring it in as a breach of trust. Reactivate the case with a counterclaim.
Actually, Christian, this maybe be a good time just to go over the where you were going to ask me about the possessory title and the beneficiary title.
Right.
So you're saying the possessory title is the legal title is 9/10? That's what I got on my notes here.
You're kind of muffled there. Say again.
Sorry, you're saying the possessory title is the legal title, which is the 9/10?
Correct.
Okay, so by the same logic, then the beneficial title is, hang on here, beneficial title, the 1/10 is the equitable title.
Yes, or the beneficial interest or beneficial title, and that's in the beneficiary.
Yeah, that is, I must have had it backwards, because I was thinking equitable title is the use of or ownership.
No, equitable title is the same as synonymous with beneficial interest or beneficial title. Equity is private.
So okay, well I guess
patent law trustee. Equity is beneficiary.
Okay. And that's right across the board. That's pretty universal. That's pretty general. There's not exceptions to this or anything, right? Generally speaking.
No, it can't be cut and dried, black and white. That's it.
Okay. No, it's probably not the first time I had something completely backwards. But there's a lot. That means I know a lot of people that have this completely backwards as well, because that's where I got it from.
That's why I was bringing it up again.
Okay. Very good.
So how does that, was that expression, possessions 9/10 of the law, what does that mean?
Good question.
Yeah, that's legal title. That's liability also.
So that means, like, even though the state has the title, I mean, you have your car, the state has the title, they have 9/10, and you have 1/10, even though you have possession of the vehicle.
Yeah, you have possession of the colorable title, the certificate of title, which is the 9/10 possessory title, the legal title. It's not possession, it's possession of the title.
Yeah, the focus used to be on, in my misconception, was always on the legal title being the most powerful thing. But it's now clear that you're saying the equitable title.
It's not beneficial. The 1/10 is the most powerful one.
Which is the equitable title.
Correct.
Okay. I got that on my chart here. And I rearranged that.
Yeah.
When and how would you use the three same terms, equitable, beneficial title, or beneficial interest? Would they apply in different contexts?
No.
So they're intermatched
discretion.
Okay. There's no rule.
No. Not that I know.
Okay. Do you favor one?
No, I've used them all.
Okay. Equally?
No, I kind of beneficial interest, beneficial title, equitable title. You know, I've mixed and matched them all on.
So you're just saying, like, according to the sentence in the context generally.
Yeah, whatever rhymes better. Yeah.
If in a mortgage situation and
keep it consistent, though. Keep it consistent in one document.
Mm-hmm.
Okay, but if the bank is getting interest off of security, then you would refer to that as beneficial interest.
If a bank is getting interest
off of promissory note.
Yeah, really. That's colorably. Colorably, so yes.
Oh, colorably.
And you guys can take title and record and use those two terms synonymously as well.
Yes.
Now, when you talk of these two terms, when we use this legal title or equitable title, when you're in the closing in an escrow and you are purchasing owner's title insurance and the bank is purchasing lender's title insurance, there's two title insurance policies. They only allow you to be aware of one, which is the one for. But there's a second one. So is one of the title insurances must be on the beneficiary title, and the other, that must be the lender's insurance, and then the owner's insurance is on the legal title.
Why do you keep coming back to the insurance? The bond is insurance, and insurance is a promise, and a promise is my word, and I can promise to do anything.
Well, because I've been doing a lot of studying on the title insurance, and
colorably they're using title insurance as a credit enhancement. That's all they're doing for securitization purposes. They're over-collateralizing the account so that it looks more attractive for securitization.
Okay. But in the owner's title insurance,
it's an illusion. It's an illusion.
Except written into them gives the purchaser the right to have them pay for legal fees if the chain of title is broken.
Yeah, so it's debtor creditor. How's that tie in with trust?
Well, if you're not a hotshot attorney like all the other guys on the line, and you get into a high-profile situation and you actually do get CC&Is and a PO in place, then you may have to partner up with a name in order to go in there, and it would cost money. And so if the owner's title insurance called for paying for those legal fees, why not take advantage of it?
Is it a 100% coverage?
They have both. Usually the owner's is, usually. Unless the owner, kind of hoodwinked a special deal and he split it, and he's taken the loan and he's just, half and the rest of it, whatever the equity was at the time for the owners.
Right. So that's just another avenue so I could use that in my tool, the litigation toolbox, to use.
To pay for things.
Right.
Yeah, that's all.
Right.
Which is great to know. You never know where you're going to need it.
Let's try and stick with the trust topics, though, really.
Okay. But it is on the trust, but it's just that if you get into a situation where you want to appoint an attorney as a trustee agent on the public side, that's what I was thinking of.
Yeah, you could use that possibly for a litigation enhancement for getting somebody to take your case on or something like that. Yeah, but again, that's
right.
Litigation. Well, these calls are litigation purposes. I don't claim to be a litigator. I'd like to keep these calls all on a trust basis.
Okay.
Christian, may I bring it back there now?
Yeah.
All right. Now, I'm a little bit mixed up on a couple of things that we talked about tonight. And first, when you were reading that Corpus Juris Secundum, you were talking about that on the public side, we may be better off to claim being trustee.
Yeah, colorably, yeah, you can be trustee.
Okay. So now I'm sitting here thinking about...
Defend it, but don't claim trusteeship.
I'm sorry, repeat it.
Could do that.
Repeat that, I'm sorry.
You could be just a defendant and just keep it quiet that you're trustee.
Okay. And I'm confused because when I'm looking at the way that we were talking about how to fill out the UCC-1 when we're transferring and we're claiming, and how we got in collateral block or in the block 1, we're going to maybe name the judge as trustee. Well, if that's the case, then do we want to alter the way that we were filling out the UCC-1?
Yeah, unless you want to do a co-trusteeship for...
So if we're filling out...
they know how to do the instruments. If I could give them the special deposit, now that I have trustee position, they should be able to accept my special deposit. I'm trustee making a special deposit. Why would they have any way to disclaim about or complain about that, really?
So what I'm really trying to get at is if you're gonna suggest that we might want to be trustee, how are we going to fill out that UCC-1 and how are we going to conduct ourselves? Are we going to, for example, put the judge on there as co-trustee, and are we going to actually make that designation, or just put trustee, and then when we get in the chambers, for example, make that announcement?
Well, let's look at it this way. How would we come about enforcing it?
If they were,
hang on a second. If the res gets passed to the trustee because they're the co and they fail to make the payment, well, then we're going to go ahead and go for breach and ante.
How about this? Let's start thinking of a multiple trust. What if I'm giving him as one trustee to another trustee, like what Jacob was saying? Because as trustee on this trust, I have a right to make a special deposit, and whoever I'm making the special deposit to, aren't they trustee? Trustee in relation to the special deposit?
For the court?
Yeah, so I could be trustee on this case, but I'm making a special deposit to another trustee, the judge, with another special deposit to him.
All right, now here, this is my
res that I gave him, kind of like within itself, a trust within a trust.
All right, here's an interesting scenario. Let's say you go ahead and you make the record that the judge is the trustee.
Wait a minute. Oh, it's like the judge is not trustee over my trust that I'm trustee on. The judge is trustee over just the trust res that I gave him as trustee.
I'm with you. Okay. And you go ahead and you transfer res over just that trust, all right, and the judge disclaims or the judge recuses himself and another judge steps in. Now we're going to have to go ahead and do another public filing of the UCC 1s and 3s to move that, to have the records?
So because you did an appointment, he's trustee. Did he receive trust res?
He received it.
Okay, who's trustee?
No matter what they do, once they get the potato in their hand, they got it.
Right.
Okay.
So that's our judge?
If new judge that's on this case comes in, well, Your Honor, this old judge, he's in breach of trust. Why don't you go get him?
Yeah, go get the res. He's got it. Don't look at me.
You just can't give it to him again?
Why? We already got a scapegoat.
You've talked the ball is really what the message is here, right?
Sort of like the original lender, right?
Yeah, judge sitting on the bench. Go fry this judge that's off the bench.
So you're saying you can assume that it's already been settled in the private?
Yeah, he's breached the trust. What's he doing with my res property? Has he applied it? Has he given it back to me? He's in breach of trust. Go get him.
Is he in breach of trust? We don't know. We have to assume that they did their job, right? Because that's two separate issues. If he wants to walk off.
Now, bottom line, if the debt isn't extinguished, he's in breach.
Right? What's the time limit on it, guys?
30 days.
I'd say 7.
Put the caveat in there, give them a time limit so that you can certify it after a certain effective date.
All right, now in the morning I got to go to court and I'm going to bring my prima facie records and my protective motion and my protective order, hoping I'm going to get in chambers. Once I'm in there, this should be a very quick event, right?
There was a couple things I wanted to change up. Well, I just made a couple little tweaks on it. I don't know.
I've made quite a few changes since we talked last, Shane. But that was a question for Christian. That should be a very quick event. It should be as simple as here's the records to show that the res has been transferred to you. Judge.
That's documentation. I think there's the evidence and got the evidence.
And at that point, all I need to do is order them to go ahead and apply the res to extinguish the debt.
Yeah, order to conversion.
Order to conversion, okay.
Christian, if you do this merging of the titles without doing the UCC 1, what do you think the effectiveness, how much lessening is it by not doing the UCC 1 and 3?
If you're merging the titles, yeah, you're going to do it by the 1s and the 3s. I'm like, That's a foregiven.
Oh, okay. So in other words, it's kind of a mandate that you do the 1s and 3s in order to have this occur.
Yeah, that's a mandate. Yeah, that's the only way you're going to merge the title. That's the only way
You got to create the asset title.
Yeah, you got to use the moving titles platform to merge the titles. You got to create the evidence, the records.
All right.
And there's only one way to do that, and it's to create the asset title.
Yes, right.
And when he orders the conversion of the trust res, that's it. I order the conversion of the trust res.
Yeah, I could. If the res needs to be converted to apply it, convert it. If not, extinguish the debt.
And then at that point, order any proceeds therefrom back to the beneficiaries.
Correct. Right.
Or direct.
Either way, same thing.
But in that particular case, if you've got the court acting or the bank acting as beneficiary, of course, obviously, that was trickery, and you've got the grantor settler that is closing or merging the titles. Now, in that particular situation, who's going to be the beneficiary? You certainly wouldn't want this to be the bank.
Right. You'd have to do the reappointment back because it was misconstrued. That was some point I really wasn't bringing out. At the time that you're going to do the appointment that the bank is the trustee, you got to tell them also that you guys have misconstrued it. You're not the beneficiary. I am. You're not the beneficiary.
Yeah, so that was a missing part right there.
Yeah.
That's right.
So at that point, order a check.
Well, no. At that point, you're ordering the bank as the trustee, and then you're correcting the misconstruement.
Right,
Yeah.
and you're ordering dispersion, which means I should walk out of court tomorrow with a check.
Well, hold on. If the bank's not the beneficiary anymore, and you notify them that they're the trustee,
Order the deposit back, and when they don't, they're in breach of trust.
But there's no more merging of titles anymore, right?
You could transfer your beneficial interest to the trustee as beneficiary.
Oh, really? And make them trustee and merge it that way?
Yes. Yes.
Don't you mean
they were supposed to give it the disbursement to the beneficiary at that time? Who was the beneficiary? You were.
But you actually meant settler, not trustee.
What? I missed that.
Oh, yeah.
Okay, so
yeah, you could come in and correct the misconstruement as settler. Yeah, right.
But you're the remainder settler. You're not the original settler.
Yeah, I am.
Yeah. What are you talking about?
I am the original settler. I am the original grantor. Yes, I am. Who signed the instrument?
Okay, if the trust res is, if the asset title of the promissory note is the trust res, and you also have the payments that you made as trust res, and you also have the interest from the security instrument as the trust res, and then you're ordering the special deposit back of the promissory note, and then the beneficial interest of the payments of the interest back to the settlor.
Back to the settler? Yeah, because the settler and beneficiary are synonymous. There's one and the same entity.
Because the settler and which are synonymous?
The settler and the beneficiary are one and the same. You.
The settler and the beneficiary.
Yeah, the settler or the grantor and the person who owns equitable title, Chris.
That was Jason that you were talking to.
Oh, I'm sorry, Jacob. But anyways, back to what I was saying is tomorrow, after I order a conversion, and then once I convert, then I can order disbursement, and I should walk out of there with a check, correct?
For the overage? For the bonds and proceeds, yeah.
Yeah. And if they fail to give that to me, they're in breach.
Yep.
Okay. So
Yeah,
what do I do? Ask for a statement of accounting on this
limit? Or give them a time limit. How much time are you going to give them?
Okay.
You might say they're going to send it to you in the mail.
All right, and then ask them for a statement of accounting on this? Huh?
You better put that instruction in there then.
Okay. But I can
you're
do
talking to fiction puppets, and you got to tell them exactly everything you want them to do. How are you going to get it in remittance?
Can I do that all orally in chambers?
Yeah, sure. Uh-huh.
Okay. And then order a statement of accounting?
Yeah, so you could or order a release statement.
Or a receipt, basically.
Yeah, send me a release.
Are you saying relief or release?
Release. RELEASE.
Oh, thank you. Okay.
Eric, when you distributed the copy, did you do that before you made your corrections or adjustments?
No.
Okay. Because I do want to get some feedback, guys, at some point.
We all do.
No, I do in particular.
Yeah, we'll talk about that privately, Shane.
Very good.
Back on the beneficial title again.
Say it again, Christian.
Back on the beneficial title again. The
Back on
interest, beneficial equitable interest, beneficial title, beneficial interest.
And question, I got a question actually about beneficial title in reference to my situation in the morning. Once I'm in chambers, because the beneficiary is private, would it be appropriate to even announce that I'm the beneficiary as well?
No, I was just reading that where it said that the beneficiary was, how do they word it here? In an action at law by the holder of the legal title, that would be the trustee, it is not necessary to give the name of the equitable owner. That's the beneficiary. And a trustee plaintiff need not state the name of the beneficiary. So you really don't need to name the beneficiary.
All they need to do is have an address where they can send payments within 3 days.
Right. But they may have to know who to make a check out to.
Yeah.
I got a minute. Are they making the check out to the res dent?
They'll probably make it all out in the all caps name, I imagine. I don't know. Unless
So
they
if
got
I-
some kind of manual bookkeeping system where somebody makes it out by hand.
Well, if they're making the check out, do I want to tell them that it's to me since I don't need to disclose the beneficiary?
Yeah, they're going to have to make it out to someone.
You could make it out to you as trustee, and you're going to disperse it to the beneficiary.
I was just thinking about that. Okay, good. There's my answer right there. So I can still keep the beneficiary private.
Yes, right.
I remember when Tom Schultz was talking about this, and it was the first time he mentioned trust to me, but he was saying, because he does this, right? Because he'll drive without a license and stuff like that, and they'll pull him over, and then he will go back to collect. And he said the way to look at it was like he was the beneficiary and the cop was the trustee, and you're holding him accountable. And he said at the time the indenture or the grantor, I think he said in this case, was the Highway Traffic Act or something like that. Does that plug in at all?
What was that comment last?
Well, he said the third party or something was the actual Highway Traffic Act itself. So I think he was saying that was the grantor in this example or something like that. Because he was saying that he was the beneficiary and the cop was the trustee. I remember that. And he said and you're holding them accountable in essence. And he was making reference to breach of trust and so on. And then I don't know what he did in the court because I never got that close to it. But somebody else did tell me they drove him up there, and that's where I got the thing about they told him that they would just deal with it by mail.
Yeah, by mail.
Well, yeah, it was as close as we got to a confirmation. My friend, I knew the guy who drove him up there.
Hey, Christian. Christian, this is Victor from Minnesota. Talking about that Eric's, and it was mentioned about a release. Shouldn't he ask for a discharge rather than being released?
How about release the funds to me or release the instrument?
But you want that debt in a public discharged. And then if there's any overage, return that back to the trustee.
Okay, I'm back on. I got cut off.
Oh,
we were just wondering about that.
Did you hear? This is Victor from Minnesota.
Yes, go ahead.
Okay. When talking about Eric's thing tomorrow, and it was mentioned that you should ask for a release. Should he not ask for a discharge in the public? Because he doesn't want to be released again. And settle it and get it discharged, get it off there. And then if there's any overage, return that back to the trustee.
Yeah, the discharge would be more colorable for them to look at that way, yeah.
Yes, thank you.
And what were you talking about there about
I was just remember when I first heard about this, and Tom Schultz was actually trying to explain this to me, and he had made reference that his view, he was trying to explain it simply, obviously, and he was saying something to the effect that he was operating as some kind of beneficiary, that he considered the cop to be the trustee, and he made reference to the Highway Traffic Act as the I think he said the grantor. But now I know that doesn't make sense to me now, but I think that's what he said then. Because I knew he was saying he was the beneficiary and the cop was the trustee. And he was going in and he was explaining how he was going in and collecting.
Mm-hmm. But he was collecting as beneficiary.
Okay. But again, like you said, there's lots of ways this works, right?
Yeah, I don't think there's a whole lot of different ways how this works, right? It's either going to have to be you're collecting as trustee for the beneficiary or you're the beneficiary collecting.
Well, also, too, you might want to look at it from the point of view that the officer is a trustee with the intent to collect, to settle the debt, and you are the trustee as the losing party to your straw man. So you got two different trustees that have to work out some kind of a meaningful settlement.
Yeah,
so that
kind of is like what I think JC was talking about, where they're trying to act as trustee to collect for the debt under the misconstruement. Really, you're supposed to be getting the funds back, but they never give the funds back to you. They abscond with the funds.
Yeah.
And then diverting the funds and sending it to the Queen instead of you.
How can we clean that up, Christian? I mean, you got a thought on that one?
Yeah, correct the misconstruement that they're not supposed to be getting the funds, and if they don't give you the funds, they're going to be in breach. We're not expressing the trust. That's the whole problem.
So like maybe a writ of error or a correction in error or an error in presumption or something of that nature would be suffice?
Well, I think it was Section 345 under the restatements that said that during a mistake I can correct everything.
Okay, what manual is that out of?
The restatement on the second, Law and Trust.
Oh, okay.
I believe it was Section 345.
Yeah, I think maybe you're probably right about that.
Anybody else? Question?
Yeah, well, that would be a little bit like what we're trying to do with the IMF, is that we're trying to restate or to reset the status.
Yes, right.
It'd be real close.
Correct the misconstruement.
Mm-hmm.
If that's the way you want to play it.
I had an interesting exposures to some new thought today I wanted to share with you. In the mortgage papers, it was brought out in our local group that the settlement papers actually shows the debit and the credit sides are equal, which means that is full payment. And those are in the closing settlement papers of each and every one of the deeds of trust. And I never even knew it. And it was pointed out today that the account is zero at the end of that day. I was floored. I was shown a couple of different examples, and the amount that was being debited was also credited, and it zeroed out the account on every deed of trust.
Well, doesn't the bank only ledger the one side because they've moved the book on the other side off book?
Well,
even in their own bank?
The closing and settlement statement says at that moment when you receive those documents that it's completely cleared off the books.
Uh-huh. Well, that's probably why they never wanted you to do the UCC, why they never did the UCC, because that was your trust receipt, which was a record of the payment. And a trust receipt would be the same as probably the trust deed, warranty deed.
Mm-hmm.
Wow. Tammy in Minnesota here, another Minnesotan.
Go ahead.
Thanks. I've been listening in the background for months. There was a gentleman last Wednesday, Paul Robo Paul, that gave out his email address, and maybe you guys can help me if he's not on the call, but he said he had a sample NOI and SOI, and I tried emailing him off of that email he gave out, and both bounced back, trying it both ways with underscore and dash. And that's kind of what I'm looking for.
Yeah, I'm on the call.
Oh, okay.
What can I do for you?
Well, I need a sample NOI and SOI, and for starters, and I also know there's 4 qualifying things in regards to protective order, but for starters, I need the NOI and SOI.
Okay, I can send you a copy of what I filed a notice in the county today for the claiming.
Okay.
And I'll go back probably Friday and file a notice for the transfer.
Okay.
And in the meantime, this Thursday I'm helping some people. We're all going to sit together and do the UCC filings. So, and I believe Christian said that you can file those now, and anything that happens in the meantime, you'll have your number handy, the IRA number that you're going to mail to yourself.
Right.
So you can get this groundwork done now, which is what I'm doing. And if you want to leave your, it's Robel, WROBEL _ Paul at yahoo.com. And you can email me anything, and I'll be able to reply to you.
Yeah, I tried that, and it back. I don't know if your email box is full or.
No, it's not full.
ROBEL_Paul@yahoo.com.
WROB as in Bell, E as in Eric, L as in
Oh, wait a minute. ROBE.
Yeah, WROBEL.
W.
Yes.
That's what I was missing. ROBEL.
Yeah.
Robo. Not just, I was just going with R. Okay, gotcha.
Correct, right.
Yes,
And I'm going to send you the example that Christian had posted on his website. That's the basis that I started with. Okay?
All right, wonderful. Thank you.
Yeah, I'm glad to help you. Thanks.
Thanks. I'm out.
Okay, anybody else?
Yeah, I have a question. This is Paul. A question about the UCC3. Basically, pretty self-explanatory here. Just want to make sure we're going to be assigning this to, in my case, it would be the judge. And his information is what we're going to be putting in on the changed or new information. So his information will be in there. Now it says on that line 7, changed or new or added information, it says type of organization, jurisdiction of the organization, organizational ID, if any. That's not going to change from the UCC1, correct? It's all going to be the same as what was on the UCC1.
Right. Mm-hmm.
Okay. And the UCC1 was, now the UCC1, say on that first line, the debtor line, say I put the information there for my birth certificate, the address were to order one, where I get one from. Like in my example would be I was born in Niagara Falls, New York. And the address would be like Main Street, all of that. I could tie in my birth certificate to this claim if I put the address where they wanted to, the mailing address where they could order one if they wanted to double check if it was legit. If anybody in the country would want to double check. What do you think of that if I tied in my birth certificate with the debtor? And any number that's on that birth certificate, I could put it on the organizational ID.
Possibly, yeah.
Okay, all right, that's all. That's what, when I'm reading that form, that's what I'm seeing. That's what I'm perceiving that I want to put down because that's how I understand it, So, somebody mentioned, you did surrender your birth certificate in court and this, that, and the other thing, and I'm thinking, well, that was the Rain Trust that was originated. That was the Master Trust, and when I was born, that's what I feel is the debtor. So, that's what I'm going to do. So I just wanted to run that by everybody if they wanted to try to tie in their birth certificate to a court case or something. It's something that the judge understands. Because when they threw me in the slammer last week, they were asking me date, where I was born, date of birth, all of this information, and I'm thinking, well, they want to know all this information so they know where to go to get the birth certificate information. And
well, you know why they ask for that information? Because when you give it to them, that's the proof that they need that that's who you are.
And you're making joinder and giving them jurisdiction.
Yeah, but I signed everything I gave them as grantor beneficiary. I don't care.
Yeah, but you blew it when you said all that.
Well, did you express it as a special deposit and ask for it back?
Originally, when I gave the policeman the indenture, I expressed that I wanted it back, everything back, in the little indenture that I handed him before anything happened.
Treat all that as a special deposit. Form the records that you made that special deposit with those documents, and then put in the order to surrender those deposit documents back. when they don't return them, then they're in breach of trust.
Right. In the letter I'm going to write, the special confidential private letter that I'm writing to the judge, I'm listing all of case numbers, docket numbers, and you name it. And telling him everything you've been saying. You know, I'm writing my letter here as I'm listening. And, telling him that without recourse, I granted you my qualified name. In confidence, with reliance, for future return with all proceeds therefrom, including my interest in kind after use, for the settlement of claims, for the confusion of debt, and the merger of all debt titles and all equitable asset titles. In other words, I direct you to complete the conversion of the principal and the extinguishment of all debts in this matter. I direct that all my original records be segregated for future return after use, non-pro-tunc, and demand the immediate return and disbursement of the special deposit to the beneficiary upon completion of this conversion, and order the release within 72 hours. Make checks payable to trustee for Paul L. Roble. And I don't want to go on and explain to him what he had done to me.
Did you say extinguishment of debt?
In other words, I direct you to complete the conversion of the principal for the extinguishment of all debts in this matter.
Okay. All right.
Yeah. So that's just part of the letter. I'm adding maxims in law, and, the first paragraph, without waiving any right, remedy, or defense, whereas I, grantor Paul Roble, with confidence.
Keep it simple. Don't put a whole lot of stuff in there.
Don't put a whole lot of stuff. This is to the judge, and I'm understanding that I'm going to be mailing this to him privately.
And just give him enough information that he has to do his job. Don't give him any more than what he needs.
Okay.
Also, but Christian, when they ask him for name, birth date, all that stuff, and he says, gives it to him, then he's also saying that it's his birth date, and can he say that as a trustee? Because he's operating as a trustee there, and then he's turning around and saying, now it's mine. And
yeah, but if he's operating as a trustee, then there obviously has to be a trust, but then we got to treat it as a trust. And then
getting in some, don't you think they're getting it in some kind of reach?
Trustee, and that, excuse me. If it's a trust, he's operating as a trustee, then it isn't debtor creditor.
Right, but then if they ask him, what's your name, and he doesn't phrase it in such a way as to say, the name that you're asking for, the registered name, and the birth date, which is only alleged information, they can't reconstrue that right there?
Well, they may.
At the very least, he could be termed to be like double-minded or something like that. You're showing how subtle I think it can get.
Well, he gave him the name once, didn't he? I mean, if he gave the name once, then I would say, I was asking the name again. I don't grant the name again.
Exactly. Well, right there, I don't think he just gave them the name, right?
If he gave it to them one time under restriction, under granting for special deposit, try to trick you again to get it some other way for debtor creditor, I don't grant it for that.
And the birth date that's very clearly asking for the birth date. That's basically when the trust was created, right?
On the first signature, yeah.
Yeah, but every signature I gave him was qualified.
So how did you answer those questions when they said, "What's your name"?
I never answered it. That's why they arrested me.
Oh, you refused?
Yeah, I wouldn't give him my name. I gave him a little indenture, asking him, telling him I'm going to grant you my name, my name for future return after use with all my interest. Then I signed
okay.
the indenture.
How about what did you say when they asked for your birthday?
I didn't give them any of that information until I got into the jail, and now they weren't letting me out of the cell until I answered their questions. So I was going to rot in there. They wouldn't even let me make a phone call. They wouldn't even give me a blanket. After 3 days. I got tired of it.
This needs to be studied more.
Yeah, so everything I signed was grantor beneficiary, and it's a trust.
Just to interpret exactly what you did, you'll keep track of what you did for really detailed information, because I'd like to go over that piece by piece and then try and interpret what was going on with the judge and the court. There's got to be a tiny, what I call micro behaviors. Just like if I watch somebody on a computer and they insist they're not doing something wrong, if you watch close enough, they are.
Hey, dude, I can't describe what happened.
Try to. Keep track of it, man. Write notes down.
Yeah, even the so-called orders that he was going to write, he was writing before the alleged arraignment. I signed grantor beneficiary as surety, you know, and he just papers. I mean, I signed over trust rolls to him. And
go over that and journalize it, man. And then, I mean, that's going to be worthy of a lot of going over and over and over. I bet you there's a ton of information in there somewhere. Something's going on.
Oh, yeah. I mean, they wouldn't even give me the alleged arraignment was by television, you know. And I didn't even have all the charges in front of me. They ramrodding me on getting on guilty pleas.
Well, I wonder, do you think somewhere he might have breached the trust himself, Christian, somehow?
When I signed my grantor beneficiary signature, surety, they got rid of that paper. It's gone. There's no copies of it. I went to the courthouse today to find out there's a new one. And
oh, wow. Yeah, I've heard of that. Wait a minute. Give me that again.
When I went to the courthouse today to gather anything that anybody had submitted, what do you call them? Anyway.
The clerk?
Yeah, I went to the clerk to see whatever papers they had on it, any file papers. And I told them, because like I said, they didn't give me any. And
did you have the original case number?
Pardon?
Are you saying you're looking for a certain case number? Did you have the original case number?
I went there to get whatever, what do you call it?
Whatever, just the evidence in file or the disclosure.
I just want to see whatever the judge orders to the court and any.
So the minute orders or the docket orders?
Yeah, right. The docket orders, complaints, anything anybody had put in there against my interests.
So you had the case number then, right?
Yeah. Well, yes.
Okay.
And when I saw that paper that I had signed as surety, because I don't think we should move forward until I had my signature. And they weren't going to admit that I had handed it to the cop. Nobody was talking about that. That paper I gave him disappeared. And
you don't got proof of, there's one thing there, I guess. Are they getting him on, he can't prove all the process that he did?
They can't. The judge didn't want to be trustee,
Well, that's interesting, because that's what we were just talking about.
What did they replace it with? Something that was forged to your signature or something?
No, they replaced it with one that didn't have my signature on it. So in other words, I wasn't the surety anymore. In other words, that signature is no longer in their files. So I have to ask him in this letter.
Whoa.
He did the trust res that I gave him. And if he claimed it, who did he appoint? And if he lost it or kept it in private, what do you do with it?
So maybe he's on the right track, and they're so desperate they're playing totally dirty, and maybe he's got to go in there, redo the whole thing with witnesses.
Well, that's why these UCCs are so important. Because if he didn't want to be trustee at the beginning, when I first put my signature down, my qualified signature, I got to make him trustee of the UCC3. That's the way I see it. So.
What's your name, by the way? Sorry.
Paul Roble.
Paul.
Yeah.
So you're the guy giving out your email earlier?
Yeah.
Oh, man, I don't want to ask you again, but maybe send something to me at my email. It's easier to remember.
Okay. Well, when they gave me the opportunity to get out, and it was either a big, this was like driving after suspension, some stupid trumped up charge, a couple of Class A misdemeanors. But when they finally let me get out, I signed the bail grantor beneficiary. Anytime I can put that grantor beneficiary down, I did. And I'm not writing a single thing back to them. Even when I have to put a motion for continuance in, I want to put that RA number on that thing, on that motion. So that's why I filed everything today at the county. So I have that RA number ready to go. And but I'm presuming I have to mail this letter to the judge in the private by notary. Unless you think perhaps it might be better to not to mail it in the private.
Or maybe just with witnesses in the private. Because I don't know, if you do it through the notary, doesn't that make it public?
Right. Well, I'm going to mail it to them by a third-party witness. And those are the only witnesses I have that I claim trust. Because the cops gave me back the wedding indenture. So I have that. But that's another case. I got to do the process on the police. Just to have it done correctly. So, anyway, I'm not too upset. But I don't like them going to jail. Never been in jail before. But I think I put the fear of God in them. I don't know. They were pretty afraid.
Yeah, sounds like it.
Yeah.
They're like messing with you.
The hordes of hell were against me.
You must have been really hot on something then for them to do that. Especially I think the thing that gives it away is the stuff is all missing. That's the giveaway.
Yeah, not everything. Just that first signature that I gave to the judge before they got anything out of me. The first signature, and I guess that probably established.
So they're saying they don't have it, or they can't find it, or they're denying you gave it to them.
The clerk of the court said they don't have it. They must not have sent it to us. And I said, well, there's a new one here. I said, and where's the yellow copy? Well, we don't have that. I said, and then I told her, I said, I'm claiming trust here. And if you're going to take, and then she started giving me the copies of the complaint. And I made her put the court seal it like to certify that I got it from the court. The cop never gave me one.
Oh, she wasn't going to do it initially. She coughed it up after the fact.
After I told her I'm claiming trust, then she started, putting her little notaries, the court seal on the document, the copies, the photocopies, to certify that I got them from the court.
Huh.
Because before that, I didn't have anything. I mean, they wouldn't give me. They wouldn't even. They put the plea. They were. I was going to say no contest, and they're saying not guilty, not guilty.
Well, at least this story sounds more realistic to me.
Yeah. Well, like I said, when they're forcing something down you, there's maxims in law. If there's anything under duress, you're not guilty for. They're forcing it on you.
But I guess it gets back to that principle I've always said to people, I don't know how to do it necessarily, but one way or another, you got to have cameras, you got to have witnesses, you got to have some way. If you can't come back a week or a month later and say, this is how I did it because here's the copy, proof, evidence, whatever, then no use even doing it with these people.
Well, if I do it under notary presentment and with the penalties of perjury, and they have to respond the same way, otherwise.
Yeah, I think you should just go do the whole same thing all over again, but this time have all your records and copies and witnesses in place.
Right, and the UCC1 and the UCC3 and the county filings, those are the only witnesses I have. Ipso facto.
Maybe just get some people there, some eyeballs.
I got no witnesses in the 6x8 cell. There's no witnesses.
No, not before you. I mean, if you're going to go back and try to follow this thing up, maybe that's all they're trying to do is shake your can, right?
No, they want to incarcerate me.
Like they already did, and you're out now.
No, the prosecutors, like the one on one charge, there was a bench warrant out for me that I didn't know about, which who knows who put that in there, because I went down to the court in Laconia and I tried to figure out, I said, look, I'm putting a motion in for continuance. I said, I'm going to have to mail a copy to the prosecutor. What's his address? And they said, well, it's the police. I said, I never heard of a police being a prosecutor. And then on the other court, I asked the same question, and it was a deputy sheriff as the prosecutor. So the attorneys don't even want to touch this. They have a higher level of education, I guess. Trust law, And
The oath is to the bar.
Yeah, so they don't want to handle anything that. I mean, the other guys, the police and the deputy sheriff, they don't have privity of any of this. I don't know if you're doing deputy sheriff. Who ever heard of a prosecutor being a deputy sheriff?
Are we finished with talking about trust this evening? Because I can go and let you guys continue.
Well, we're talking about trust.
Well, what are we supposed to talk about besides trust?
Is Christian on the call?
Okay, I'll let you guys talk about trust. I'll keep you posted if you want.
Yeah, absolutely. Sorry, Paul, what's your email?
WROBEL_Paul@yahoo.com. But the idea was I was just talking about how to tie in the birth certificate onto that UCC-1 so it can be brought in to court. And it might be helpful. I mean, I haven't tried it.
Yeah, well, those are the people that count, the ones that try it. WROBEL_Paul, right?
Correct.
Paul,
Thanks.
are you in? Oh, I'm sorry to interrupt. Paul, are you in Minnesota as well?
No, I'm sitting in a chair in a little log cabin in southern Maine.
Oh, Maine. Okay. When you said Waconia, there's a Waconia, Minnesota, so I just thought I'd ask about that.
Yeah, Waconia, New Hampshire, and Rochester, New Hampshire.
Very interesting. I think you just struck a nerve with the whole, police system.
No, they were rattling my cage. Yeah, they were rattling my cage, and I was rattling their cage.
Yeah, and that's what happened there.
Hey, Paul, this is Eric. I'm sorry I didn't have much of a chance to talk with you today, but hopefully in the next few days we'll get a chance to talk.
Yeah, no problem. I've been out at work, and I know you have, and those motions you sent me helped, because I have a little better idea how to write them up.
Hey, is Christian still on the call with us?
Yeah, I'm here. Chris,
Oh,
you still here?
Hey, Chris. I got a question for you. In doing the nomenclature change on some of the online filings, you gave us the language before, but I don't know what I did with it. When there is no box to do a nomenclature change, how do we open that up in Block 4?
I think we're putting it down as grantee/grantor, and then we had a little X for a little box. We put it in, and then we put nomenclature change.
So that's all you're putting in collateral Block 4 to designate that these that this form is a trust is to indicate a claim of a trust. That's all we need to put in collateral Block 4.
Yeah, we're just stating a nomenclature change to grantee/grantor.
Okay.
Chris, you still on? Chris Summer, you still there?
If he is, it might take him a moment to come back on. But I got one more question for you if he's not.
You had something I think you wanted to talk about the meeting they had with the banker.
Yeah, it's exciting to hear about that. I hope he is still on. if he does come on, maybe he'll come on in a minute. Tomorrow when I open up, should I open up with my name is what I'm known by commonly in the public, but then should I also make a statement that I'm there by special appearance?
Yeah, you could do a special appearance. Special appearance would be private.
I think at the top of it, I was looking up in the dictionary, there's such a thing, too, as a special motion, or do you think that title's sufficient, Christian?
Yeah, well, I think special is signifying privacy.
So just put that on top of the stipulation and proposed protective order?
Yeah, or even non-negotiable, really. You know, all this stuff is non-negotiable. That's private, too.
You could say, did you say non-negotiable special motion? Or special motion, just put non-negotiable and then put, or put special motion, then put non-negotiable?
Well, I could put, like in the footer.
Yeah, header footer, yeah. And put, yeah, with the document ID number and all that stuff.
Mm-hmm.
The gentleman asking more about staying private when he went in, verbally when he went into court. I would just go in and accentuate the word when you're stating that you're there as special appearance. Just dwell on that word as under special appearance, because then you're there as king, just asking questions. And don't even give the name. Just you're there as that matter, you know what I mean?
But they're still gonna say, well, who are you?
You're there under special appearance.
And they're gonna say, I'm gonna ask you one more time, and if you don't tell us, then I'm gonna go ahead and issue a bench warrant for the guy that's not here.
Right, and then that's when you say the name in all caps, you know, just not the middle name, but just the name, and then that's.
That's when I'm going to start granting my name with the restrictions in confidence and reliance.
And that's when you're going to say as, and pause.
If you ask questions,
the form of a question when you give your name even.
Yeah, people got to try asking these questions first and then seeing how it works out.
Well, I don't want to figure out what works out. I just want to know what language I want to open with, and I want to get that from Christian, so I can go ahead and get my protective order, my motion and my protective order issued, so I can get out of the outlaw side, the culpable side, and get in where equity is, where my substantive rights are. I don't want to piss them off too much.
Exactly.
I don't think Christian's going to disagree with speaking in the form of questions as your fundamental approach.
Well, let him speak, please.
That's why I just set it out, so he can speak.
Thank you, Shay.
Yeah, that's where I'm going to start granting my name.
With qualifications.
Yeah, I'm looking for the little statement thing here. Where's that?
You're looking for what?
My little comment sheet.
You got a little...
I got my cheat sheet.
Your cheat sheet, okay.
I got it.
You're picking that up.
Christian?
I give you my name of confidence with the reliance to be returned in the future, along with my proceeds therefrom with my interest.
Oh, man, I hope I had the recording going. Hang on.
Is that with my interest or with the interest?
No, my interest.
I give you my name. What else is it, Christian?
In confidence, what?
Yeah, I give you my name in confidence. With reliance, comma.
With reliance?
With reliance. So I give you my name in confidence with reliance. And then to be returned in the future. Along with the proceeds therefrom.
Now we know who's got the clicky.
With my interest.
And that's it, period?
Yeah, so again, I give you my name in confidence with a reliance to be returned in the future along with the proceeds therefrom with my interest.
That's got to be memorized. Is that right?
Yeah.
We got to memorize that one.
And now if they try to get your name on something else, you like say, well, I don't grant you that right to take my name for anything else.
That's a real nice conditional acceptance, isn't it?
I do not grant my name. I do not engage in granting my name again.
Oh, yeah, that's right. I have that there, too. I do not engage in any further writ of execution on the transaction. No.
Yeah.
How did you say that?
Yeah. I do not engage in that execution. Yeah.
Okay. Yeah, I think you said writ of execution yesterday, and that's equally good, too?
I think I made writ of execution in reference to enforcing a trust.
Okay, no, that's possible.
But a writ of execution.
Okay, yeah, that's possible. I was writing notes. I scrambled them up. So, Eric, did you say you got your 1 and 3 in, or you still haven't done that yet?
No, I'm about to do it here in a few minutes, and I guess I'll print out the web page, and that'll be my prima facie evidence, and that'll be my NOI. So I'll see if they'll act on it.
All right, and would you mind if I get copies of that, just so I got 2 little samples with me?
Yeah, well, yeah, I got to figure out what how I'm going to sanitize them, but yeah.
Thank you.
Can I make a suggestion to what you might say to the judge? You know, you could go into that court and ask him what his name is. And if he says, if he remains silent, you could say, well, by your silence, I presume you agree with me that your name is whatever's on his nameplate. And for the record, by your silence, your continued silence, you agree with me that your name is Judge Roy Bean. Now you're set up, you're in control, you go with your next line of questions. Are you aware that we are operating under an express trust? By your silence, I presume you agree with me.
I was making a lot of assumptions how the judge is going to operate.
And I don't think the judge is going to let it go that far anyways.
Yeah.
It's only 3 questions, you know, and you're going to maintain control. Once you get his name before he gets yours, you're in control. Until you're not. You get it in for the record that you got his name, and now, you know.
I don't know if the judge is just going to straight up give you his name.
They will give you their name. I've had them do it.
You're right. That's why you're going to, by his silence, you agree with me that your name is, you know, you can write whatever. Say whatever his nameplate says on his desk.
No, the reason he's not going to give it to you, he's not going to grant you the rest. He knows better.
He's not going to give it to you. If you're silent, if he's silent, you can move forward quickly and say, you know, by your silence, I presume you agree with me that your name is.
So, but I don't think that's going to happen.
And you know what I think I'm going to do? I think I'm going to piss that judge off real good, and he's going to make it real hard for me, which I'm not trying to do. I'm just trying to get into chambers where they can recognize me as a real man.
How about this? I am the beneficiary. You are the trustee. I have the right to take your name.
That's true.
Let's see that again. I am the beneficiary. You are the trustee. I have the right to take your name.
And if they disagree, I'm sure they'll speak up.
Would they be obligated to they're in a position where they have to disprove that now? If they wanted to back away from that?
If I made the claim, Your Honor, you're aware that you will have to prove up the claim that you're in breach. Or you'll have to prove the claim that you're not in breach if I make the claim that you are in breach. Because I'm the beneficiary, and if I just make the claim
equity is going to assume that you are in breach.
And you can say that because you're also
got the record.
Oh, you're doing that with the 1 and the 3.
You
That's
can
your
say
power?
that because you have the proof. They don't.
Or is it just you can do that because you can because you're the grantor, and you can say you're the beneficiary? Where's the power coming from in your position there?
Yeah, because you're the one that specifies who the grantor, or who the beneficiary is, because you're the grantor.
Okay.
I love that, Christian. I would take that and run a step further with it. I am the beneficiary. You are the trustee. I have the right to take your name. Do I not?
Yeah, of course you got to put it in a question. Absolutely. You should always practice it. You can't practice it enough.
Well, wait a minute. Does the settlor even ask questions, or do they just order command and direct?
Well, it's more powerful.
Well, those are both.
I don't think the settlor even needs to ask questions. Does the king ask questions, or does the king just make orders?
A wise king can put it in the phrase of a question, which is basically a command.
I would agree.
That's by the power granted me by the grantor. I, as beneficiary, have the right to take your name as trustee.
Do I not?
Mm-hmm.
It's as simple as that. You can take any statement and make it a question. Give them the opportunity to dishonor you.
If you said, give me your name, and you do not give me your name, you are in dishonor.
Because they have the duty as trustee to
Yes, the beneficiary, the ultimate owner, is there.
So as beneficiary and then being trustee, they have the duty to.
If you don't give me your name, you will be in breach of trust. That's it.
Okay.
Are you prepared for that?
And Christian, once again, what's the judge specifically the trustee of?
Because I granted him trust res. He's got my signatures. He's got my name.
Okay, and then what are you trustee of then again?
Or I'm trustee of the case.
Okay.
Hey, and on the 1, do I want to go ahead and put the case number, or do I want to put my RE number?
What are you going to do with it? If it's going to go in the public, I'd put the RA number. If you're going to just keep it private, use the case number.
You mean if I make the claim in the public? What do you mean?
Yeah, if you're making a public notice, then I would use the RA numbers.
Okay. And if I was just keeping it in the private, I could use a case number. Okay.
Yeah.
So if I wasn't filing, for example, online. And the reason why is because they create the case number off of my private res.
Uh-huh.
Okay, even though that case number, but
that
doesn't make
the device to keep it private. It's an actual manifestation to keep it private. It's an act, the deed.
What if there's already a case number?
Order. I'm doing some kind of active thing to keep it private, which shows it's secret. It's CCI.
the case number.
Yes, to hide the case number, yes.
So even though they made it public, I hide it, and that's an act to show CCI.
Yeah, I would object.
All right. That they've taken my private information and put it in the public.
If they're breaching the trust, they did that once you give for breach of trust. They're commingling it.
And I don't know if Paul's still on the call, but Paul, one of the things that you might want to try when it comes to dealing with the any of the officers, for example, on the side of the road, or where you interact with them directly, you might be far better off just use an ellipsis that they don't recognize and go back and handle this in court as opposed to standing on the side of the road with a gun.
Hey, dude, this guy volunteered his name, and he accepted the trustee position when I asked him if he wanted to be trustee. I just went with the flow, you know. And he wanted my name so bad. He wanted my name so bad, I gave it to him, but I just happened to put the qualifiers to it. And, you know.
How did you qualify it again? On the ticket?
I wrote out a little indenture. I asked him for a piece of paper. He tore off a little paper out of a notepad, and I asked him for a pen, and I wrote, I give to you my name for future return after use with all my interests in kind after use. And I signed it grantor by grantor beneficiary Paul Roble. And I said, here's my name. Transfer
wow.
Right there. And that's what started. And then we, of course, I wasn't going to give my name to him. And he gave me back the wedding copy and took a photocopy. So I know he gave the photocopy to his captain or to the judge, you know. And that's when it started. That's when,
is that usual that they give you the original copy back?
Well, I'm glad he did, you know.
Yeah.
So,
what was going on there? Was that like an accident, you think, or was he following some kind of protocol, or what the heck?
No, he just photocopied it and gave me back. Well, I made him take it, you know. I wouldn't let him put it down, you know.
But going back to practical application and staying out of jail and not dealing with all these people that aren't quite sure that you're scaring the crap out of, you're far better off to go ahead and do the ellipsis and then create the records and dealing with somebody, for example, a judge in the private who understands how to deal with this. Because when you're dealing with these guys who are conditioned in the debtor-creditor world, world, I think you're playing with fire there.
I agree with you. It's just like you're not talking to the decision maker, really.
Right. No one needs to know or understand that the trust is being formed. It doesn't indicate the trust. They're doing it to you in the courtroom, day in and day out. The prisons are full of trustees. Okay. And this guy had all he could have said no. You know. And now he did it with full consideration. You know, the judges understand all this. And
I understand they do that, but still, you paid a pretty rough price for your brazen act, and I'm not suggesting you don't do it. I'm just, you know what you dealt with.
Yeah,
that's all.
You know, like I said, I wouldn't do it any differently. I think I would do differently. I wouldn't have gone out that day and drive, you know, without this. Anyways, it's done deal. So.
Well, I just suggest you use the ellipsis in the future.
Explain ellipsis. What's that?
Actually, I'll just run by and ask you that too. Basically, that's where you're putting by ... and then a little space and putting the full colon and then the sentence.
No, you're not doing by.
I wanted
you don't. Oh, exactly. Well, what are you putting?
I wanted everyone to know my intention, and that was that. It was to try to comply with what he was demanding. So. That's all.
Okay, can somebody clarify on the ellipsis then?
Yeah, it's just ... and then your name. You don't do anything else.
I understand.
We're not signing on behalf of?
It's simply ... You're going to tip them off to too much, and when you're standing there with a guy with a gun on the side, don't tip them off.
Oh, okay. We could put by ... but you're saying what you do is you just put ... full colon?
It's the purpose if you put by and then ... because the by is going to give it away.
Right.
The ... you might not notice, and they usually don't so far, and then my name. And the ... signifies all the missing stuff, and the missing stuff is by grantor.
And you know, a word of caution to everybody out there. You know, I feel like Paul and Mike, it was, well, I think Paul got kind of lucky because, you know, he only got put in jail. But what if you get some hothead cop that wants to, you know, beat the crap out of you or put the boots to you or shoot you and because they said you came after him and then you're injured for life because you can't walk. You know, there's some serious hotheads out there. You've got to be careful what you're doing.
I did just say that's my signature because I do have that right on the driver's license.
But you better realize that not every cop out there is a gentle, kind, caring individual.
But if they actually get to the point where they're seeing it, they're going to see it's on the driver's license.
But Shane, this isn't for you. This is for everybody out there. Be careful. There's some very volatile people out there that you might be dealing with in situations.
But I agree with you in principle, just in the sense that, you know, it's you're not in a courtroom, so you're not where the business can really get done, and you should just be cooperating. I'd never really be putting any resistance towards a police officer. I wouldn't do it if I actually thought that I didn't realize, because I noticed in my own experience, they don't even notice that kind of thing. The closest thing
and when you start acting up, they're quick to put the boots to you, okay? Make no mistake. I have some friends that have been to prison, and they will beat the crap out of you.
Well, there's no reason for resisting them because, of course, they can misconstrue that. But, you know.
Well, let's just put a word of caution out there and make sure we don't mislead anybody. Let's just be discreet about this.
So the principle is simply like always I mean, I guess it goes without saying, but let's articulate it. It's, of course, you're always cooperating with the police officer on the side of the road, out in the middle of nowhere, and then you get into the court, and that's where you do your business. I've always stated that.
Okay, we obviously have the statement out there, and I hope that everybody is careful to use an ellipsis and not be brazen and alert these guys that are dying to beat the crap out of it. There's one everywhere that's just dying to beat somebody up.
Ego trips. No.
Make no mistake, they're full of them.
Mm-hmm.
So I just I've heard some horror stories, so that's why I say that. Not to scare anybody, but it's better to be aware than not to.
Okay, anybody got anything further?
Hey, Christian.
Hey, Pete.
Hi. Someone asked me, because I helped them out with doing some movements of titles earlier. So I met up with them and we went through some of the stuff. And he went into default, and the court had sent him the application. It was like an acknowledgement and also an application. They were saying an application. But we couldn't find that in the documentation, but we'll get to that in a minute. So he's gone into default on a loan, and then he done a notarial protest, because the website that he'd been looking at said, wait until you go into default and then do a notarial, like a lien sort of thing, lien procedure.
Right.
So he did that, but he didn't do it by notary presentment or anything. He just sent them some letters and counted that as being a certificate of dishonour or whatever. He's done the 3-step, fault, default, and but there's no witness to the fact.
Right.
So now he's asking how can he sort of, utilise trusts and moving titles. He does listen to the calls, So we went through everything with him. Now, while I was talking, I didn't realise that he'd gone into default. And then I thought to myself, well, that doesn't even matter. It's not even in the right jurisdiction. And it says on the paperwork, please fill out the application if you are in agreement with this jurisdiction. So I've told him to, do his private documentation, tell him that he'll disclose under a protective order, make whoever he's writing to, the court manager, the trustee, and they have no powers of discretion for lifting the protective order. Well, I didn't say for lifting the protective order, but they've got no powers of discretion. So I just wanted to run that sort of by you, especially in the instance where he's in default but we're bringing it in trust, so the jurisdiction of the default doesn't really count, does it?
Does he have any kind of public witness at all? Any
Well, he's
or some attempt to have a third-party witness, like maybe an independent party, make out an affidavit, or...
Yeah, he's going to do an affidavit, and he's going to do the NOIs and SOIs, and I've told him to document it on there too, as well as claiming the property and the transfer.
Has he put anything in the county to claim the lien?
No, he hasn't.
Oh.
But he will be doing.
He needs an affidavit of obligation or some kind of claim for a lien to be recorded in the county. And then he should put in there his documentation that he's got along with it to back it up. Because he doesn't have a lien until he makes it public in their realm. And then he's got to age it days.
Let's back up, though, Christian. I think what he was saying was that the guy went into default because he didn't have, correct me if I'm wrong, he didn't have a notary public, so the guy's in default.
No, it wasn't that. No.
No? Okay.
He went into default, and then he done a lien process.
Okay.
Because the website he was looking at said, wait until you go into default, and then start your lien process.
Mm-hmm.
I said he was a bit foolish there, but either way, it's in a different realm.
What's the issue then when he's in default and he's trying to do a lien in this case, or just just like his way of expressing the trust through this lien, or there's a couple things going on there? It sounds like.
It sounds like he's trying to do a counter asset to do a set off against.
Yep. And he's also now wanting to sort of express the trust. So he's coming out of the jurisdiction where the default is, but he's saying, I've got my own default now. That information's good about doing the affidavit of obligation and putting in the public notice that the lien exists.
He's taking
so I told him to do that.
Sounds like a kind of adversarial approach.
It sounds like he's trying to go from debtor creditor, now wanting to jump into trust, right?
No, he's doing.
I think. Correct me if I'm wrong, but
he wants to go trust.
Yeah, exactly. So he needs to find something that is trust res and start all over again.
Well, he knows what that is. We've identified everything. Like all it is that he's done a lien, so he's wondering, can he utilize that? Well,
yeah,
I'm saying, you should try.
I don't recommend hybrid.
Sorry, what was that, Christian?
He could run a hybrid, but I don't recommend a hybrid. He could take the lien and use it as trust res, but that's kind of like mixing the apples and oranges.
So lien by definition is plain in debtor creditor?
Yeah, the lien would be debtor creditor. Yeah.
Yeah.
Okay. And what's he trying to do?
Maybe I'm not saying it well then. All he's done is he's done the lien, but that's by the by.
Go back where the first signatures were applied on his loan application or the note, say.
Exactly. Yeah.
Okay. Go back to that.
That's exactly what he wants to do. Yeah, and he is doing. But at the same time, he does have some of the documentation, and he was wondering, would that be of use? So I said, well, you best go on all trust. But when you do your documentation for your notices...
Too bad he didn't have a certificate by a notary, because the notary could use it to jam it up and claim the unclean hands and then come in the court of equity and do an enjoining action or possibly even get the foreclosure kicked out.
Brilliant. That's probably the one. Yeah. Yeah, do that certificate of dishonor, yeah. Yeah, I knew there was one little piece that I never went over. That's great anyway. That's pretty much it.
So that was a mortgage you're talking about then, Pete?
No, a loan.
A loan. Okay. A secured loan or an unsecured loan?
I don't know.
Well, that's
one other thing that kind of struck me there with it was that putting the account reference number into the trust and the court case into the trust, into the private documentation. Is that
into the trust stuff?
Yeah.
Yeah, you could do that, but then again, that'd be kind of around a hybrid, though. Again,
would be running a hybrid. So would it be better doing two separate trusts, having the loan account as one trust and the court case as a second trust?
Oh, I see what you mean. Oh, okay. I thought you meant the debtor-creditor lien, incorporating it into the by numbers. No, yeah, you could combine both those two into one. Yeah.
Into one. Yeah. That's where we've come at. Yeah. Yeah, that's great. Then I'll keep you updated as to what happens with him. Okay. But he just wants to bounce it out the court, really, and as you say, come in at a court of equity. That's what he wants to do because he wants to set up a precedent.
Well, if he had the unclean hands certified that they didn't validate the debt or they did something wrong, then that would have been what he could have used. The notary certificate to do that.
Well, he could still do that, couldn't he, as grantor beneficiary?
Yeah, he could ask for debt validation, yeah.
Yeah.
Have the notary certified.
Yeah. And then he can give that to the court with the unclean hands and
equity
case closed.
Have the person doing the foreclosing, they can't ask equity to do what equity is required of them to be doing.
Yeah.
They can't have unclean hands and ask equity to do a foreclosure. So that kicks it right out.
Yeah. Superb.
Okay, it's almost 1 o'clock.
Christian, real quick question on the UCC1. Do I fill in the trustee and the settlee and settlor on the organization name block or on the individual?
The organization name, what about it again? Do I put in what?
Do I fill in the organization name or in the individual name on block 1 and block 3?
I'm trying to picture what without looking it up. I think organization, that's, did we decide we're going to put trust in there?
I'm thinking we did, because when we went through it before, that's what I filled in. I'm just wondering, for example, the settlee or the trustee, do I want to put that person?
Organization is a trust there on the organization block.
Say that again? One more time?
Did we lose you?
You still there? Oh, crap.
I think
hello?
I can hear you.
Hello?
I think he said
hello?
put in the organization name.
Can y'all hear me?
I can hear you.
Okay.
Hello, anybody?
Christian,
hello?
Can you hear us? Christian, can you hear us? No. Christian, can you hear us? We're still waiting on you, Christian, if you can hear us.
That sucks when you have to call back in just to say goodbye, eh?
Yeah. I think he said decide on trust or not, and then he finished with organization name, and then he
dropped out.
Yeah.
He might be popping back in. We'll give him a couple minutes.
God, I hope so.
For your sake, right? Because you got your big day tomorrow.
Well, it might be him. Hey, Christian. Yeah, you dropped out for a moment.
Yeah. What was it? I forgot what you asked.
It was on the one when we're filling in to put in the trustee and the settlor. Okay, on block 1 and block 3, are we putting that in organization name or in individual name?
I think the organization name. That's the organization is really the organization is a trust. Is that the block you're talking about? Organization block?
Right. Exactly. Because the only other blocks we can fill in within one is individual.
The individual block, that's where you put, I think it was the Social Security number, but then that makes reference to that block clear over on the right side. If you use the one on the right side, you don't use the one on the left side. If you use the one on the left side, you don't use the one on the right side. So I forget what the one on the right side's name is. And then in between is the organization block.
So we boiling this down to that we should put it in the organization block? Is that kind of where we're going with this? Would that be a proper, can you hear us? Christian? Christian?
Hello?
We can hear you. Christian? Can anybody else hear me?
Yeah. He said if you use the one on the left side,
yeah, I heard what he said.
The one on the right side and vice versa?
Yeah, I'm back. Can you hear me?
Yeah, we can hear you.
I don't know why we dropped out again somehow. But
I had to shut my Skype down and start it back up because I kept on getting cut off of Skype earlier. I think sometimes after a while you just might have to. I don't know if you're using Skype, but
no. Well, that block on the left, that's the individual block, and then there's a block clear over on the right-hand side. I forget what that block is entitled.
Well, what we got, for example, under block 1, we got organization.
And then in between is the organization block.
Yeah, well, the first block is
organization. The block on the left, the individual block, that's where we were putting in, I think, the Social Security numbers. If you use that block, you didn't use the one clear over on the right-hand side. But if you use it, I think it was an alternate identifier on the right hand. If you use that number, put a number in there, then you didn't use the one on the left, the individual number.
Okay. So, for example, if I put the judge in there as the settlee or the trustee, am I putting that in organization?
Can you hear me again?
I can hear you. Christian? Hello?
Shit.
I don't think you're putting the judge in the debtor's box. That's going to be...
Yeah, you got to. Absolutely. No doubt about it.
Did you catch that?
Yeah, can you hear us?
No, I couldn't hear you. No.
Oh, can you hear us now?
Yeah, I can hear you now.
Okay. Well, what I'm trying to get at is, like, for example, 1A at the top on the left is organization. You still there?
Yeah, that would be the 1A. That's the that would be the trustee name then.
Okay, that's what I thought. All right, good then. You just might have been thinking about the blocks in a different order or whatever, but that's what I thought. That's what I had in the example. I just wanted to confirm that with you. Okay, then down on 3A, we're going to do settlor or trustor or grantor in 3A. Because that's organization, correct? Still with us? Oh boy, he might have got dropped off again. Anybody else still on?
Yeah, I think you're right in what you said.
So 3A on number 3 is grantor?
Yeah, I got an example of this. Who's speaking?
Paul.
I'll shoot that to you. I don't know. I might have shot that to you over Skype already. If I didn't, I'll share that with you now.
Okay, so the debtor's name up top, on number 1, the organization's name, you're going to put the judge's name in there?
Yeah, I'm going to send that to you right now, Paul.
Okay, thank you.
Well, what if you got an attorney and it's not a judge coming after you?
It would still be whoever you're claiming to be trustee. Who's speaking? Who's the lady?
This is Tammy, Minnesota.
Tammy, you on Skype?
Yeah, I've got Skype.
What's your Skype ID?
No, Tammy at, shoot.
Tammy, how about this? Why don't you just find me on Skype? My Skype name is Imagine the One.
Okay.
And request the UCC1 example of how to claim.
Okay, we'll do.
All right, unless you want to get it from Paul, because I just sent it to him.
Okay.
You see that, Paul?
I'm looking at it now. Something came in, yep.
All right, I got Paul's email too, so I can get that from him tomorrow. But he's swamped too, but okay.
Is that you, Christian? Christian, is that you? He might have gave up for the night.
Hi, sorry. What happened there? Did everybody fall off?
Nope.
No, I'm still on. This is good information.
Oh, okay, I crashed there. That was weird.
Okay. We thought that when we heard the ding, that might have been Christian coming back on, because he had dropped off about 4 times and came back on. So we were. Now, are you on Skype, Shane, dialing in? Or are you dialing in from the line?
Yeah, I'm on Skype.
Did Skype crash, or did the call just drop on you?
No, it's probably the modem, my supplier.
Oh, okay. Right. Okay. All right.
So, yeah, and so if Christian's having problems, he might even be in a position right now where he might be rebooting his operating system or something like that. It's a hassle when, if you got to reset your modem, sometimes it takes a few minutes, depending on what happened to him.
Okay. Well, I'm going to sign off, Tammy, Minnesota here. Paul, I'll email you tomorrow, and I got to get up early and drive a dump truck, so I got to go to bed.
Yeah, I'll check my email in the morning and fire off those examples to you.
All right, wonderful. Good night, you guys. Take care.
Paul, follow up with me. I'll be happy to how I can.
Okay, that's Imagine the One. Okay, thank you. Good night.
But Paul, that was you. I was talking to you.
Oh, okay, what did you ask?
I know. I just said just contact me if there's any way I can help you. I will.
Well, you're helping me right now. Because this is the next thing I have to file this week, and I have people coming over Thursday, and they're looking to me for the answers. And I don't know everything, but.
Well, you're gutsy though, and you're going out there and you're doing stuff, so you're going to learn about 10 times faster than the other people.
Well, just don't be so gutsy. You get thrown back in jail.
No, you don't have to be. That's right. It's not about being gutsy, but it's about getting in there and negotiating with these people. It's about ambassadorship and knowing how to ask questions and asserting yourself.
Oh, I just sent you something else too.
You had to be there. Okay, I got the lingo here. I put the terms with.
Oh, you're real low. Just so you know, that all night long when you've been speaking, it's been real hard to hear you.
Okay, I've got the Florida Uniform Commercial Code financing statement that you sent. Now, organization's name, it says all terms with EE at the end go here, such as grantee, settlee, trustee.
Who's that who just came on?
Christian here.
Hey, would you have to reboot?
Yeah. So.
I told you so.
Night.
Yeah, I had the same issue earlier. All right, well, glad to have you back on. We were just chatting about the one, and it all makes just fine sense to me now that you shared that with us on the organization name.
Right below the organization name, what little block is on the left side?
Let me go back to it.
Individual's last name.
Like one I or something? On the
right below, it's an individual's last name on 1B, you mean?
Right.
No, not B. One I.
One I.
It's the line below on the left side.
It goes to a maximum of G. 1G.
So what's 1G?
1G all the way on the right-hand side, down on the bottom is organizational ID.
Okay, if you use that number, the number on clear on the left, then you don't have to use that number.
Okay. So if we're using organizational ID, how do we know what the organizational ID is, for example, if it's a court, for example?
Well, that would be their EIN number, say.
What if you don't have that?
And I think the one on the left is then the individual number.
What if you don't have that EIN number?
The other on the right, you don't have to use the one on the right. If you use the one on the right, then you don't have to use the one on the left. You use one or the other.
What if you don't have them when you're filling out the form online?
Okay, well, it could be different. Maybe it's on the hard copy. But then on the left side, that number that goes in there, I think the next block over from it to the right, one block over, is like organization name or organization or something. And then that's where we're putting in is a trust or a trust.
Christian, you're a little muffled.
Type of organization, it says, yes.
But if we don't have either one of those numbers when we're filling out the information online, what do we do?
Don't worry about it then.
Say again?
Don't worry about it.
Don't worry about it. Okay.
Now, I just want to ask one more
put
time.
it in the collateral block.
Collateral block itself.
We put it in the collateral block.
Okay. Grantor, grantee, you put it in the collateral block for the alternative designation would be in the block 4. You're just going to add it because I noticed on the electronic filing we didn't have an area where you could tuck it in any other place. So let me get.
You put Paul. You can put in on number 8 optional filer reference data. You can put trustee trustor, and if you're filing online, then that covers the trust.
But the challenge with that is that you don't have that opportunity to always get those designations or those drop downs when you're filing online. Not everybody has that. Not every state has that.
Well, I use Washington.
Now, wouldn't you want to put grantor, grantee?
Even if you don't have the, depending on what state you're filing in, even if you don't have that, you could still just do a nomenclature change designation that Christian described earlier that just simply goes with, I'm looking for it now.
You want to put grantee / grantor.
Yeah, grantee / grantor.
That's right. You want to put grantee / grantor. Not grantor / grantee.
Okay, grantee.
You want to put grantee first / grantor. Because the first block 1, that would be your debtor. That would be your trustee block. So you want to put grantee, which is then a trustee. And then your 3 block is your secured party block. That's grantor.
Okay.
What I put is note this is a non-UCC trust filing. All fields are comported to set lead / set lore nomenclature change.
Right.
And the reason I use set lead, set lore is because this is something where the res has already been granted that I have an interest in. This is not something I'm about to do. This is something where a transfer has already taken place. That's why I use those terms.
And then of course, 1B and would be the judge's last name, first name, middle name. Suffix would be judge.
Oh, yeah, good question. Do we want to put suffix, or do we just put judge right in the organizational name?
Yeah, the suffix is only Mr. or something like that. Mr. or Miss or Ms.
Actually, we're not even going to put the suffix because we're just going to put the name in the organization's name.
Right.
And the name would be the trustee, correct?
Or Setley, depending on where you're at. If is that Paul talking? Yeah, you're gonna do Setley because you've already granted you've already transferred res.
According to the Corpus Juris Secundum, Mr. and Mrs. and titles do not apply in application to the name. Also, junior, senior on the end doesn't have anything to do with the name. So it's just so-so. Anybody catch that?
Yeah.
Yeah. You said Judge so-and-so. What question? It was a little hard to hear you.
Well, the judge so-and-so is just doesn't apply to the name. Just like Mr. and Mrs. doesn't apply to the name. Or just like junior or senior doesn't apply to the name.
So when we're putting it in the organization's name, don't even put judge.
Doesn't apply to the name, no.
Thank you.
So it would be Setley, whatever the guy's real name is.
Would you put Setley and then their name, or their name then dash Setley?
Yeah, you could put that on if you wanted. I don't. It's really you change the nomenclature on the form. Setley would be the same as what the trustee.
Yeah. Why would you be using Setley? That sounds weird.
Christian, if you're naming a corporation along with the officers, you could put the organization's name under the debtor as well as the individual's name as a CEO, for example, couldn't you?
Yeah, so for XYZ Corporation.
Well, then how would you put that on your UCC-1?
Leave it all in there.
Huh?
Leave it all in there.
Just put it all in there on one line?
Yeah, can you get it in there?
Can you? Yeah, you.
Unmuted.
I was just wondering if would you be considering the CEO as the organization?
Why not put the corporation in number 1 and additional debtors in number 2, where it has individual name?
Oh, okay, that would be a good idea.
Because it says "or" for organization or individual last name in both 1 and 2. Not both.
Right. Okay. Well, you could do the same thing with the court then.
Yeah, list them as an organization name, and then the judge is in number 2 with his individual name.
All right, I'm online on the company's website, and I'm actually trying to do the filing, and it wouldn't let me do the judge's name dash Setley because you can't do abbreviated or combined names.
Yeah, that Christian said that title isn't part of the name, so why would you put that in there?
Yeah, well, I'm just letting you know how the website won't let you do it anyway. So, figured I'd share that with everybody.
This is why I ordered hard copy, because I knew there were going to be problems.
Yeah, but sometimes you got to file online because you need to make a prima facie case.
I'm going to go, guys.